Yes.
Yes.
We will not say anything, we will not take it in the first half. Let us see. 9 and 18 are one favor, 9 and 6 is a matter of 2019. Next week is the last opportunity. Next Monday. Okay. Yes. B. Fukan, Learned Counsel for the petitioner, has submitted that he is not in touch with the client and has accordingly prayed for some time to try to obtain instructions para. Considering that this matter is of the year 2019, a last opportunity is granted in this regard. Full stop. Lists this matter on Monday next date, huh? Yes. Yeah, for the respondent. Okay. For the state, on a request made by the state, matter is adjourned to be listed after a week. Ten, yes? Okay, on Friday then, a request for adjournment, consideration of this matter is deferred till Monday next. Monday, don't ask for time on Monday. Date. Four is the whole matter, madam.
No.
Oh, four, okay, four. When do you want? Okay. On a request made on behalf of the petitioner, matter is adjourned to be listed after a week. Item number 8. Again, a 19 matter. Okay. On a request made on behalf of the petitioner, matter is adjourned to be listed on Monday next. Item number 12. Yes. Yes, when do you want? Okay, Tuesday next, huh? On a request made on behalf of the applicant, huh? List on Tuesday next. What is the stage? What stage? Motion? Fresh matter? Okay. When did you file? 7th. Okay. I didn't know. Your yearly. Abdul Jabbar.
Interim order is there, no? He's on bail.
Go ahead. Who will be appearing? Applying for Home Department. You're for? Okay. P. Sharma for state. And
Yeah, on behalf of AI.
what is your name?
And now.
Okay. Yes. Yes, please address it, let him.
Yes.
Yes.
My lord, the petitioner before lordship was suspected to be a foreigner, although he is having all requisite documents to be a citizen of India. My lord, the father's name appeared in the voter list of 1965, and he was also issued the NRC in 1965. And those were exhibited as Exhibit 1 and 2 before the tribunal. My lord, the petitioner's name appeared in 1997 onwards, my lord, linked with his father. So, my lord, the ground of disbelief is the discrepancy, the name of the petitioner's father, as well as shifting. So, my lord, I categorically stated in my written statement as well as evidence on affidavit that there are some discrepancy in the name of the father, and those were exhibited also, my lord. Lordship may kindly examine 1965 voter list, my lord, exhibit 1, page number 9, my lord.
Yeah.
My lord, here, my lord, page number, sorry, my lord, page number 9. This is the voter list of 1965. Father's name is recorded as Ahizuddin. Ahizuddin, serial number 1. Grandfather is Iyazuddin.
Ahiduddin is your father?
Ahizuddin is his father. But in other documents, my lord, there are some discrepancy. Page number 11 is exhibit 2, my lord. This is annexer B. This is the NRC copy, my lord, issued by the authority, my lord. Here is also the father's name is recorded as
Page number?
page number 11, my lord.
Ahizuddin.
Ahizuddin,
Yazuddin.
my lord. Grandfather's name is there, my
Yes.
lord, but father's name is spelling mistake. My lord, the petitioner's name appeared,
Ahiduddin.
my lord, appeared in the voter list of 1997.
11 is the NRC.
NRC. This is the NRC of 1966, my lord.
66.
My lord.
Ahiduddin.
My lord, this so far the link is concerned. Page number
Go
12
go a
is the,
bit slow, go a bit slow, don't hurry off.
my lord.
This Ahiduddin is your father and he is the son of Yazuddin. So there is no discrepancy with page 9 and 10.
9 and 10.
11.
And 9 and 11.
9 and 11 are consistent.
My lord.
What is your age? 65. Okay,
My lord.
thanks.
Then, my
Next.
lord, page number 12 is annexer C, my lord. This is exhibit 3.
65.
Hmm?
Father's name.
Father-
Father's
Page number 12. Relevant part, page number 13, is the list of voters.
This is 1997
1997.
voter list.
Voter list. Voter list 1997. The list of voters, page number 13, my lord.
Hmm.
Serial number 1, Rohimuddin. He is the father, my lord. In this regard, my lord, Ahizuddin and Rohimuddin, my lord, this statement was given, my lord, already the tribunal.
Hmm?
This statement was recorded, my lord. In the written statement also, we stated that Rohimuddin and Ahizuddin is the same in one person.
Who
I-
can give, who can make such a declaration?
My lord.
Can somebody else make a declaration? Or is such declaration is required to be made by the same person during his lifetime?
My lord, I
You,
stated.
you may have two
I
names.
am-
You may have two an alias. That you have to declare. I cannot declare
My-
that you have two alias.
That I am coming, my lord, later on I am coming.
But here, what is the name of your father in
Father, my lord,
13?
Rohimuddin.
M. Rohimuddin.
M. Rohimuddin. That is Muhammad Rohimuddin, my lord.
Sit on.
Rohim Adin.
Rohimuddin.
Father was Ahizuddin.
Ahizuddin. Abdul Jabbar Bahimuddin.
Your father was, name of the father was?
Father Rohimuddin, alias Ohizuddin.
And what is his age? In 1997?
In
What medicine
1997,
do you have? Your age gets reduced? Please let us also know. We're interested.
in
In
1997,
1965, you are 65 years old. In 1997, you are 58 years old.
in 1965, age was 65.
Yes. And in 1997, he becomes 58.
My lord,
What is this minor
Yes.
inconsistency?
my lord, age is also not correct.
Minor.
This-
Minor inconsistency.
Hmm. My lord, actually, what happened, my lord, actually wrongly recorded. my
After
lord.
32 years, his age reduces by how many years? 8 years.
My lord.
Great.
Age discrepancy is there, but wrongly recorded at point of view, was not aware about. that.
Wrongly 1 year, 2 years,
Minor.
3 years. After
be-
32 years, it reduces.
Immediately brought to the notice the authority actually.
And you're relying upon these documents.
And here, my lord, page number 13 itself, the petitioner's name, my lord, serial number 3, Abdul Jabbar Rohimuddin.
Why are you trying to connect this poor Rohimuddin, poor Ahizuddin with this Rohimuddin?
Because, my lord,
Why are you trying to drag him? Ahizuddin is a different person. Let him remain in peace.
my lord,
He has already passed away.
uh,
You are not
I-
leaving him even after he has passed away.
my lord is correct, but lordship may examine page number 26 only, my lord. Exhibit 13, page 20.
This Abdul Jabbar is you, Abdul Jabbar.
Page 26, my lord.
And
And-
this Rohim Ad-Din is son of Riyazuddin. Your father was the son of Iyazuddin.
An affidavit, page number 26, shows that the
Ahizuddin.
correction, my lord. It was executed in before the notary public. my lord.
And this has a brother also. Not brother, yes. Basiran Nessa. Basiran Nessa cannot be male. Why is it written male? Who is this Basiran Nessa? At page 13.
Basiron Nasa is the mother, my lord.
Yeah, this one.
Male.
Huh? MI.
Mother.
Samat. President.
So, if you go by this, your first document is a document of 1997, where your name has appeared as a 22-year-old person in the voter list of 1997, along with one Rohimuddin. You kindly show us the legacy of Rohimuddin, that he was there earlier also.
My lord, this Rohimuddin, my lord, was also examined, my lord, before the SDW2, my lord. That I have annexed, my lord.
What did he say?
My lord, page number 45, para number 4.
Yes. No, where is the document of Rohimuddin?
My lord, page 46, only 2 lines may be seen, my lord.
No, where is the document of Rohimuddin, apart from 1997?
My lord, the Rohimuddin's document, my lord.
And even if you assume for a minute that this Rohimuddin is Ahizuddin, okay, that is the projection.
I am
Then-
having a Jamabundi copy.
No, from 66 to 97, where was Ahizuddin or Rohimuddin? Both went missing.
66 documents.
See,
was
page 9 and page 11,
11.
65, 66.
My
Then the next document is of 1997. Intervening documents?
My lord, intervening document was not collected, my lord, every year's document.
No,
we
not
want-
every year. From 96 to 66, 66 to 97, how many years? 30 years.
Actually, we was under impression that pending of the case of the tribunal, that some link documents is required. That is
So where
why
is that? Okay, where is the link document?
the,
Link document names are different.
my lord,
Age are different.
as Jamabundi copy was also exhibited, my
Let
lord.
us see where is the Jamabandi.
My lord, page number 19, my lord, exhibit 9.
What is 15? Page 15.
Yes, page 15.
15 is what?
Page 15 is the voter identity card of the petitioner, my lord.
Not voter identity card. Page 15 is not voter identity card. 2014 voters list. Page 15 of your writ petition. Annex D.
Sorry.
Annex D.
Uh,
16 is voter.
yes,
Wrongness.
page
2014 voters list.
my lord.
Rohimuddin.
Rohimuddin, Riyazuddin. Here petitioner's name at serial number 3, Abdul Jabbar Rohimuddin.
Rohimuddin here is 75. So this is with 97. Okay. And where are you? Abdul Jubar.
My lord. Serial 3.
What is his actual father's name? It is Rohimuddin.
Rohimuddin is the father's name, but earlier, my
It was
lord,
wrongly recorded according to you as Ahijuddin
Ahizud,
originally.
originally.
Actually, it is Rohimuddin
Rohimuddin,
according to you.
same person. Lordship,
Then page 16 is what? Page 16?
my lord. Page 16. is
Epic.
the voter
Epic
list
of whom? Epic of your mother.
my lord.
Relevant. Why irrelevant? 17 is your epic.
My lord.
EPIC of petitioner. Then Jamabundi's page what?
19, my lord.
20. Yes, what is 20?
My lord, 20 is the vernacular, my lord. 19 is the translated copy of relevant part. Abdul Jabbar, son of Rohimuddin.
This is of which year?
This
2015.
is my lord,
2015.
15, my lord.
How does it make any difference? How is it relevant?
My lord, page number 20, certificate copy obtained on 2015, but the land record, my lord, 1988, my lord, as per order, my lord.
How does it make any difference? 88. We want a connection with your father. Assuming that this voters list of 1997 is the correct voters list which reflects your name as a 22-year-old person and your father is Rohimuddin, we have to have a connection that Rohimuddin is a citizen of this country who is residing here prior to the cutoff date.
Rohimuddin's name was not recorded in the earlier voter list 1966 or like that, my lord. His name comes with his son, that is the petitioner, from 1997 onwards. That is why this discrepancy was categorically stated in the written statement as well as the evidence also, my lord. His father was examined as DW2 and his father himself said that his name is, my lord, wrongly typed out, Rohimuddin alias Wahizuddin. That is, I have annexed, my lord, DW2.
Is it enough? Documentary evidence is not necessary.
My lord,
That is not the principle here in these kinds of cases. Even father, mother, anyone cannot give oral evidence. It has to be, all relations to be have to be proved by documents.
my lord, in some of the documents, my lord, Rohimuddin and other documents are Wahizuddin. That is why, my lord, two names are alias, my lord, that those documents are not found. That is why they have stated that both the persons are same and one person, my lord.
Who has stated?
My lord, the petitioner himself said, my lord.
Petitioner, how can he say?
No, my
somebody-
petitioner, no, his father, my lord.
Where is it stated?
My lord, page number 46, my lord.
Evidence.
Page number 46, the petitioner's father's statement, my lord. There are number 7, line number 878, my lord. My actual and correct name is Rohimuddin. Due to mistake of competent authority as
Page
Ahizuddin,
number,
page number 46,
paragraph?
paragraph 7,
Mm.
7-8 line, my lord.
Yes.
In the middle portion, my actual and correct name is Rohimuddin due to mistake of competent authority as Ahizuddin. Ahizuddin and Rohimuddin is the same and one person who is myself. And the petitioner also stated in written statement.
And what?
And my lord, and my age is 28 years at a time of 1965.
Yes, but due to mistake, this
due
shown
to
as 65
mistake
years.
of competent authority as written down as 65. So he is also stated that age is also wrongly recorded, my lord.
28 can be 65, 28 can be 82.
My lord,
That also it may be possible.
that was mistake by the writer, my lord.
How can 28 be 65?
My lord, that mistake was done by the writer, my lord. That he has stated here, my lord. That
What
is-
steps did you take to rectify?
My lord, that part, my lord,
Then what do you say? Okay, let us assume everything to be correct. From 1966 to 1997, what did you do?
Both age and name wrongly recorded.
my lord,
1966.
96.
66.
You are dragging another person, Ahizuddin, these proceedings. He's a different person. Age is different, much elder person, 65-year-old in the year 1966. Your father, you say that he's 28-year-old.
My lord, Rohimuddin himself is saying that he's Wahizuddin and some typographical.
So it can be accepted because he says.
And my lord, only due to that ground, my lord, the
So where is the requirement of an adjudication? Whatever you say is correct. It has to be examined whether the statements you have made as a witness is logical, acceptable, plausible.
but it is it may be, my lord, lordship may consider that the person is same, my lord, due to the mistake was made by the author of the report, my lord. Right.
Then you have stated that your name has been recorded in the NRC of the year 1960 as Ahizuddin. Son of what?
Ahizuddin, son of Riazuddin.
Where have you stated? Son of what?
Ahizuddin, son of Riazuddin.
Where have you written? Page 46? Page 46.
Is 46, my lord.
Paragraph 8.
My lord. My lord.
My
It is-
name recorded NRC is in the as Ahizuddin, son of late what? Blank.
My lord, deadline, my lord, is clearly written, paragraph number 7, my lord.
We are not on that, on the NRC part.
My lord.
Where is the NRC, that line? Paragraph 7, where is NRC?
NRC is not there, but the father's name is there, my lord.
NRC, the
My-
line you have stated, Ahizuddin, son of late, you do not even know. Son of late only.
Mothers.
We thought you had some case, Mr. Ali.
My lord, lordship has pointed out, my lord, last two lines, my lord, page number 46, my lord. My lord, that is, but due mistake of competent authority written down as Ahizuddin and Rohimuddin is the same in one person. My lord, I think, my lord, this is not dot dot. Actually, full stop is given two times, my lord, twice, my lord. This is not blank, my lord. This is close. My lord, sentence.
Paragraph 8.
Sorry, my lord. I mean, name is recorded in us. Yes, yes, madam. That is wrong, madam.
You're wasting your time, you're wasting our time.
Madam, lordship,
There's nothing in this to be decided.
my lord, lordship, may I pray, my lord, let the matter may remanded for exam, re-examine, my lord, by the tribunal, my lord.
You should be imposed cost.
Lordship,
You don't have anything
my lord.
to urge. All cases have something, whether we agree or not agree, we
My
consider.
lord, I agree.
There is
I agree.
nothing to consider here.
Up to you, lordship, my lord. I agree, my lord.
These are matter for grave importance. This is how you fight your case. You say it's matter of your personal liberty, citizenship. You bring a document of 1965, some Ahizuddin, age 65, then you say, no, my father is Ahizuddin, his age is become less in 1997, becomes 58. Is it acceptable?
Lordship, may dispose.
Thinking is not there.
Yes, Mr.
It was rightly pointed out, my lord. If your lordship may kindly see my lord, voter list of 1966,
Hmm.
65 at page 9.
Hmm.
And if you compare this along with my lord, voter list of 1997,
Page 12.
yes, page 12, there is nothing similarities, my lord. Only one similarity is there. The grandparents' name, projected grandparents' name is Iyaz Uddin in 1965. And in 1997, it is Riazuddin. So
Riazuddin.
Uddin is, there is only similarity in Uddin. Otherwise, everything is, my lord,
Even grandparents' name are different.
grandparent name is also different. Father name is different, grandparents' name is different, age is different, village is different. Even no single person from 1966, 65 and 97 is there. Other persons are not.
No, that the ultimate, the best case scenario, that assuming this Ahizuddin is Rahimuddin, age is also wrongly put. Then from 66 to 97, what
There is
happened?
no document at all. There is no explanation at all, not a single line. If either in the AWS or in the evidence, my lord. There is not a single line. What happened in this between? between this period.
That is also
And-
the primary determination of the tribunal,
Yes.
that Ahimuddin and Rahimuddin,
Yes.
not the same person.
Yes.
No, therefore,
Now,
it's
my lord,
fell
the-
through.
Yes, yes. My lord, in WS, if your lordship see only 2 lines in the WS,
Page,
is my lord, 29, my lord. How vague these statements are, my lord. I'll just point out para 1 there in page 29. That second party was born and brought up at village so-and-so under Dalgaon PS Dalgaon district. There is no, my lord, whisper when did he was born. That is primary necessary my lord, information to be given. Secondly, in para 2, that second party was shifted to village so-and-so from Kakalibangi, Jagigaon. When and how, why, that is not there. Now he is trying to project that 1966, 65, his parents and grandparents were there in different place. They shifted to this Dangal Khati, where in 1997 there is a voter list where his name is appearing. But when did shifting taken place? There is no explanation. So these are just projected stories somehow to manage the documents from which 1965 to 1997. The simple thing is here, my lord. The projected father's name is appearing in the 1997 first time. He has no documents of that projected father, Riazuddin, prior to 1997. He has picked up that voter list of 1965 when one Ahizuddin is there, and where the father name is somehow similar, has some similarities. And trying to, my lord, somehow trying to link with that document. That is the only point.
Linkage is not there.
Linkage is not
sufficient
there.
evidence.
Trying to link to that document somehow with that, my lord, small similarities. Now, only my point is, my lord, it is always argued by the other side that it is the creation of the voter list are created by the election. So we cannot correct it. But this honorable court has settled. My lord, just that judgment I would like to point out.
yes, please.
2018 1 GLT 372, my lord, in that case. 2018 1 GLT
2000,
2018 1 GLT 372.
yes,
There it will be probably in para 30, my lord.
name,
Name is, my lord, this is Basiran Bibi. Basiran Bibi,
B-A,
my lord,
B-A-S-I,
RON. Basiran Bibi.
B-I-B-I.
Yes, no.
Para 30.
Para 30. There, my lord, regarding discrepancies in the voter list, just I'm reading slowly, my lord. Regarding discrepancies in the voter list, which petitioner contended were not her creation, same is the case here, being entered into by the official of election commission and therefore should not be used adversely against the petitioner. Such contention is without any substance. The voter lists were adduced as evidence by the petitioner herself to prove her case that she was not a foreigner but a citizen of India. Petitioner cannot insist that only that portion of the voter list which are in her favor should be accepted and those portions going against her should be overlooked. This is not how a document put forward as a piece of evidence should be examined. The document has to be appreciated as a whole. He is relying on the voter list of 1965. He is saying that this may be ignored, this may be ignored. That cannot be. It has to be appreciated as a whole, not in part, because it is his evidence. So in that case, and my lord, first of all, to link himself, to prove himself to be citizen of India, para 26 of the Sobanandra Sunalpat says, my lord, because para 26 of the Sobanandra Sunal 2005 5 SCC 665, para 26, my lord, primary requirement is that in order to establish one citizen, normally para 26 of Sobanandra Sunal 1, my lord, 2005 5 SCC
665, yes.
Yes, para 26, it said, in order to establish one citizenship, because we don't have rules, my lord. So in order to establish one citizenship, normally he may be required to give evidence of, number one, his date of birth. Date of birth is not mentioned at all, not even evidence. Number one, his date of birth, place of birth. Number two, name of his parents. Number four, their place of birth and citizenship.
Of the
The
parents.
Yes, of the parents. Father's citizenship has to be proved. Your father's citizenship is not proved. He has no documents of prior to 1971. 1997. So if the fathers, there is no documents of father, he has no law case. And second thing, my lord, if you want to prove himself as a citizen by birth, he has to prove his birth by adducing cogent and reliable evidence. Otherwise, it cannot. So this is the only case, my lord. I think the tribunal has committed no wrong in this. That's my assumption.
Oh, close to it. Yes, we close this, huh? Write the names. With the dictation to the related. The dictation to the related.
Availors.
Well, my lord, the impugned order is at page 51.
Coming for the first time,
First time.
who will issue notice here?
My lord, she is still out, so protection may be given.
Her. Your name is not there? Mr.
They cannot, my lord.
Where is your name? Okay.
That is there.
Yes. Hard Sir D.K. Nath, learned counsel for the petitioner who is aggrieved by an opinion dated 28/8/2025 passed by the learned so-and-so, in so-and-so, by which the petitioner has been declared a foreigner post 24/3/1971. Where is the opinion?
Page 51. And 52 is my lord, first page. And opinion is at my lord. Final. Discussion is at page
Post,
65.
Issue notice returnable by 6 weeks. TGC anyone? RKD Chaudhary,
Yes, ma'am. Yes.
RKD Chaudhary, Deputy SGI for 1,
I will appear for 2, 5, and 6, 7, 1,
2, J Pang, standing counsel home for 2, 5,
and 7.
and 7,
3 may be recorded his name, my lord.
3,
G. Soma will be.
G Sharma for 3. Then Election Commission of India, okay, M Islam. I'm investor AI Ali for 4, and 3 P Sharma, the State Council for respondent 6. Extra copies. Okay, 3 Nath, the learned council praised for an interim order and has submitted that till date the petitioner has not been arrested. That's what this can did. That's a did 5,000 COT. I resaw both hands. Okay, same order.
Public.
Yes,
Well, there is an order, judgment, of course, but there is no
Yes, we have
signature.
seen that.
Only the type copy is there, my lord.
we have seen that.
Yes, Lordship, can we hear the matter phrase?
Now we can pass the same judgment. It's an elaborate judgment. And this, but
Not to your lordship.
unfortunately, it was not signed.
Yes, my
So
lord, there
it's
is no
not,
signature. That type copy is there.
not been converted. We had given, this court had also given you time for filing an appeal of 30 days.
Yes,
Now,
my lord. but
everything
there
is
no
gone.
order. But that judgment has not been uploaded, my lord. So how can I file?
No, no,
appeal, my
that,
lord?
no, this
Yeah.
judgment is not there.
Judgment is not there. It seems that there is no signatures, my lord. So lordship kindly,
If you want, we can hear, but if you want,
lordship kindly
okay, we
hear
hear.
the matter as phrase.
Yes, yes. Okay. Please.
Right now, my lord, kindly,
No, no.
today I'm not preparing, my
No,
lord.
no, we had granted you time on the last occasion. We had said we are not going to adjourn. 17 matter.
Oh, it's at least 1 day time, my lord.
We had
Tomorrow-
given you time on the last occasion. Only on that
Occasion, yes,
basis.
I was not keeping well.
Last
that's why.
occasion, we had said that we are going to
No, my
adjourn
junior
only because on
colleague-
personal basis, but not the
Yes.
move. Today, that
Then
is
2
just,
PM, my lord, because I have not gone through it, my lord. Long back, it was past an order.
why have you not gone through your matter?
It,
If it's
I
listed
thought
today,
that,
matter of which year?
matter of, my lord, 17.
17,
Yes,
and you
my
have
lord.
not said that you do not have time to go through. We'll have it
Sorry.
we'll have it at 2 or 12 o'clock.
2 o'clock.
12 o'clock.
12.
12, yes.
Oh, I have another matter, my lord, in code number.
Finish your matter and come after.
Oh,
that
yes,
we'll
my lord,
take.
yes.
12 will rise for 5 minutes, thereafter we'll take. Just a minute. Yes, next. Kudu? Which item? 19, yes.
Lordship, in this matter, your lordship, we want to withdraw our Wakalatama, your lordship.
Want to withdraw?
Yes, withdraw our Wakalatama, your lordship, because there is not an
Okay, we'll,
connection, your lordship. with the-
okay, none. Heard Sri K. Mira Learned Counsel for the petitioner who has submitted that in spite of his best efforts, no communication could be made with the client, and he accordingly submits that he would not like to appear, full stop. This court has noticed that, this court has noticed that this writ petition is pending since the year 2018, and even on the last occasion, that is 17/11/2025, there was no representation on behalf of the petitioner, and the following order was passed. Itu 17/11 to court code. Para. Also heard Sri J. Payang so and so, so and so, so and so. Considering the facts and circumstances, it is obvious that the petitioner is not interested to pursue this case, and accordingly the same is dismissed on non-prosecution.
Public. Lordship, in this matter, your lordship, we have submitted two application. I and along with my colleague, your lordship, to withdraw our Wakalatama, your lordship. And there is an office note in this regard also, your lordship.
Okay, we will record it.
Public.
Last occasion when the matter had come up, we had made the
on-
observation very clear.
On 13th also, your lordship, I have prayed for withdraw, and on that the court has instructed me to file application. To record court.
We are not saying anything on merits. If they come, we can restore.
Public.
Yes. Very. Fight for anything, vote, I go for two. Interim order of service, yes. Interim order stands vacated. Vote of- What is this? Who's appearing? Item number? 20. Human Ali, Hassan Ali. J. Ahmed, where is Mr. J. Ahmed? Normally he's a regular. None appears. None appears for the petitioner on call. Yes, you're there, madam?
Yes, Akshay. Please,
Item.
pass over the matter for the time being.
Who's appearing?
S. Ahmed.
Okay, ask him to come. We'll passing it over for the time being. We'll have it after some time. But as Jed Ahmed, who's there, madam? As Jed Ahmed,
J.
J Ahmed.
Akshay.
Okay, ask him to come.
21.
ঠিক করেছেন তবে এটা 23
May I appeal, Lordship? In this case, my lord, a petitioner adduced evidence as DW1 and DW2 is to her elder brother and DW3.
Just give us 1 minute. Nice. Nice. Who would be appearing? Payang would be appearing.
Yes, ma'am.
Yes, which page?
The impugn order is page 88.
88.
88.
Yes, let us see your documents. What are your documents? Let us see.
Our documents, my lord. Voter list of 1966, 1970, 79, 89 and others, my lord. And my lord, for the purpose of linkage, my lord, petitioner submitted school certificate which was examined by calling the issuing authority, my lord. Headmaster. And before going this, my lord, I want to attention, my lord, kindly see inquiry report, my lord, kindly see. Blank inquiry report. Page 45. There is only the name of the petitioner and husband name is appeared, my lord, and entire part is blank. And there is no also mention where from the petitioner is entered into India. All are ready-made format. Only fill up the blank. Notice to small. Notice.
Notice.
Notice, yes.
Yes,
Page 45,
40.
45.
Yes, we have seen this.
Miller?
You have seen this. It's, you say you have submitted that this is, except the name and the father's name,
Yes.
husband's name,
Yes, Miller.
rest are blank.
Yes.
Yes.
Rest are blank. And Miller, page 49 also Miller. A type copy is 47 Miller. 49 also is Miller, ready-made format Miller. Only a blank is filled up by putting the name of the petitioner. And bottom Miller, LBC report, annexed LBC report Miller.
This 49 is whose report?
Miller, electoral registration officer. On the basis of inquiry report Miller. LBC report Miller. LBC report page 45, which is entire blank Miller. Electoral registration officer Miller page 49. This blank format is filled up on the basis of Miller LBC report. Page 50 Miller finally see.
Page
Page 50.
50.
Yes. Which is Miller case diary. Five G. 50. As per Annexure B, so and so, of ERS 222 South Shalmara LSC and order SP so and so, directed to cause inquiry against the Satlukia Salaya Khatun, wife of Hanipali, village 9 Sand Block, and accordingly I open diary in my share already as per Annexure A. Annexure A means Miller page 45. As per Annexure A, one Shahur Rahman inquired the matter and suspected could not produce any document. Therefore, case could not be pending and filled up the form 7. Kindly see form 7, Miller. Page 52.
Page
Page 52.
52.
Yes. 52 type copy, original is page 54. The name of the person Miss Saleha Khatun. Father's name here Millet, wife of Hanif. A marital estate of married, village 9 number Sand Block, South Shalmara, district so and so. Other not mentioned, housewife, no, yes. SD eligible as mentioned in column number 7 Millet. This is the inquiry form 7, filled up by the police officer Millet. Thereafter, Millet, a reference was sent to the tribunal Millet. A tribunal, without going through the inquiry report Millet, issue notice Millet, page 55. And vernacular is 56 Millet. Here is also not mentioned any stream Millet. On receipt of the notice, my lord, petitioner appeared and submitted written statement, my lord. Written statement PS 58. Type copy, my lord. Originally is PS 63. I'm reading written statement, my lord. বেলেগ কেছ নাই আৰু। Written statement page 58, my lord. That the above preference case against the OP is baseless and that the allegations made herein also not mandatory both in the law and in the facts and hence denied, my lord. The OP's grandfather name is Lokman Sarkar, alias Lokman Sheikh, son of late so-and-so. He had total 7 children, 4 sons, namely Nur Hussain, Nurul, father of the OP, my lord, petitioner, Sanwar Ali, alias Anwar Ali, a baby alias Rajab Ali and Ahmad Ali are all sons of the Lokman Sheikh, and 3 daughters, namely Baila Khatun, Rukia Khatun, and Sokina Khatun. And OP's father had 8 children, that is a Kansu Sheikh. Kansu Sheikh here is my lord, DW2, my lord. Meher Ali, Somer Ali, Nasiruddin Maleka, Saleha Khatun is the petitioner. Nosima Khatun and Nazira Khatun, and OP Saleha Khatun has got 5 children, namely so-and-so. Para 3. The OP MS Saleha Khatun is an Indian citizen by birth, being born at village Jaudarsar, PS Fakirganj, district Dhupuri, Assam, where her father Nurul Haq, alias Nural Haq, Nur Hussain, son of late Lokman, alias Lokman Ali, Lokman Sarkar. Lokman was a resident of having a right of voting under 2022 South Salmara LSC and later on shifted to village Sen Block, and she has been married to one Hanif Ali, son of so-and-so, village Sen
What is
Block.
the name of your father?
Father Lokman Miller.
No. Lokman is the grandfather.
Nurul Haq, father. Lokman is the grandfather, Miller. Shifted to village Sen Block, and she has married to MD Hanif Ali, son of Badar Fakir of village Sen Block under Fakirganj in the same district, Dhupuri, in the year 1995. In this connection, one registered Kabirnama of her marriage is submitted as Annexure A. The OP Saleha Khatun, daughter of Nurul Haq, was a student of Sen Block Shantinagar LP school, and she read up to class 4. And in that school certificate, OP's date of birth has been clearly mentioned as 31/12/1970. The copy of the school certificate is submitted in Annexure B. That the OP's grandfather name Lokman Sheikh, son of Gopal Sheikh, is included in the NRC 1951. Along with her OP's grandmother, Arangabar Khatun, wife of Lokman, OP's father Nur Hussain, and her OP's uncles and aunt under so-and-so, Union 11 at village Hazrat Dewanipara, previous place of residence, and that OP's father was born in the year 1941. In this connection, certificate of NRC 1951 issued by the IC South Salmara PS is submitted. After 1951, OP's family shifted to village Bhauribita from village Hazrat Dewanipara under Saigaon PS and residence thereon, and that the OP's father, named Nurul Haq Ali, son of Lokman, along with grandfather Lokman Sarkar, son of Gopal, grandmother Rangbahar Nesa, wife of Lokman, Office uncle Anar Ali, son of Lokman, and Office mother Rabia Khatun, wife Nurul Haq, appears as a voter in the electoral rolls of 1966 and 1970 under the same house number 21 at village Bhauribita, subsequent place of the residence under the same 1955 Soigao LSC, respectively. Certified copy of the electoral rules so and so 19 submitted. Annexure B in the electoral rules 1966 of his father age is wrongly recorded as 30 years instead of 25 years. And in the electoral rule of 1970 as 34 years instead of 29 years. The office father's name Nurul Haq, son of Lokman Haq, mother name Rabia Khatun, wife of Nurul Haq and brother Kansu Sheikh, appears as voters in voters in the electoral roll 1989 at village Zhorar part 3 under house 36 of 22 South Salmar LAC. Office parents shifted there from the village Bhauribita to village Zhorar after 72 and staying there for a few years and again shifted his residence to village Sandblock. In the electoral 1989, of his mother age is wrongly recorded as 40 years instead of his actual age 46 years. The certified copy of the electoral 1989 is submitted in Annexure F. Parite. Of his father, after the year 1990, again shifted their house from village Zaurasar to village 9 Sand Block due to erosion, and the name of the office parents Nurul Haq, father, Rabia Khatun, mother, and another brother Meher Ali appears as a voter in the electoral 1997. Under the house number 1995 under 22 South Salmar LAC, and office father age is wrongly mentioned as 60 years instead of actual as 56 years. And mother age is 45 years instead of actual age 56 years. The certified copy of the electoral roll 97 is submitted. Para 9. That the office brother Kansu Sheikh DW2 here in this case. Son of Nurul Haq shifted village Chitolkati under South Salmar PS, where his name appears as a voter in the electoral 1997 under 22nd South Salmar LAC along with his wife Shahanara Khatun under house number so and so electoral 1997 is submitted. That office parents name Nurul Haq and Rabia Khatun appeared as a voter in the electoral 2005 under 22nd South Salmar LAC under house number 93 village.
You can, instead of reading this, you can show us the document.
Yes.
We can better appreciate.
Milord, I want to show the written statement which is relied upon my lord Sarvananda Sonal's case, Milord, 2005, para 26, Milord. She has mentioned date of birth, the place of birth, father's place, grandfather's place, everything, Milord. NRC 1951,
Page,
page 21. Type copy is 20, Milord. Lokman Sheikh, a grandfather, Baila Khatun grandmother, Nur Hussain father, Sanwar Ali, a paternal uncle, Rang Bahar Khatun grandmother, and others, Milord. Village Hazrat Devani Para.
This NRC primarily is of your grandfather
grandfather,
having,
issued by the officer in charge, my lord.
your grandfather had 7 children. You have said in your written statement.
Yes, yes.
But here, how many children are there?
Here, my lord,
4 children.
yes, one,
And one, of course, his wife.
yes, the Noor Hussain Miller, father of the petitioner Miller. Here is, age is mentioned. 10 years, Sanwar 5 years, a baby son
Your
of
father's
Lokman,
name is
5
not there.
Miller.
Is your father's name there?
Yes, Miller.
Which one?
Here is Noor Hussain mentioned, Miller. Actually, Nurul Haq, Miller.
Huh?
Serial number 4, Miller.
Serial number 3.
3.
This is not
Three.
Nurul Haq. This is
Yes,
Nur
Noor Hussain
Hussain.
Miller. The correct name is appeared in the voter list of 1966. Miller. 66. Vernacular space 23.
Yes.
Page 23, 66 voter list. Miller. Here is Lokman Sarkar, son of Gopal, Rangbahanesa Lokman, Anar Ali Lokman, and Nurul Haq Ali, father of the petitioner Lokman. Actually, here is Rabia, should be Rabia Miller. Rabia Khatun, mother of the petitioner Miller. Voter list 1970, page 25. Here is
Who is there?
Lokman
Rukman is there, your grandfather.
grandfather.
Then
Grandfather Lokman Miller. The great grandfather Gopal.
Gopal is not there here. Grandfather is Lukman.
Yes. Lokman's
Then
father name Gopal Miller.
Nurul is
And Nurul
Nurul
Haq
Haq
Ali 86 serial number.
is your father.
Father.
Nurul Haq Ali.
Yes. Sometime Ali, sometime Nurul Haq.
And in the NRC, he was given as Nur Hussain.
Nur Hussain, yes. Yes, Miller. Thereafter, page 20.
What's NRC is of which place?
This is Miller.
NRC is of Dhubri.
Submission of, yes, Dhubri.
And the
South
voter,
Kalmara.
voter list?
South Salmara.
Voter list?
A voter list is Bhauri Bita Milot under Swaigaon Police Station, which is mentioned in the written statement.
You have shifted.
Shifted Milot due to erosion, which is mentioned in the written statement.
Yes,
Next, my lord, page 26, my lord.
just a minute. Yes, next.
Next, my lord, 27, voter list 1979,
Page,
page 27.
'27. What is this 25?
Or 25 is the voter list of 1970,
We are not showing this.
70.
You are not showing this or what?
No, my lord, already I mentioned. Already mentioned.
No, we have just seen 66 at page 23.
66, my lord, next 70.
Just a minute, 20. 25 is the original, isn't it?
Yes.
1970 voter list. Lokman. '27 you had said.
Yes.
27.
27, 1979 voter list.
Nurul Haq is there.
Yes. Nurul Haq Ali. And mother name is Rabi.
And mother?
Rabia Khatun.
Yes.
And next, page 28. The vernacular is page 29. Nurul Haq, Lokman, Rabia Khatun.
Which year? Which year?
1980, 89. Page 29, my lord. Nurul Haq, Lokman, Rabia Khatun, Kansu Sheikh, who is the DW2, my lord. Brother.
Who is Kansu?
Brother, my lord. Brother of the petitioner, my lord. Son of Lokman, son of Nurul Haq.
Rabia Khatun is the daughter.
My lord.
Rabia Khatun is the daughter.
Father, mother of the.
Mother.
Mother of the.
Mother of the petitioner.
Is the wife of Nurul.
No, wife of.
And in this case, my lord, tribunal did not give any finding on the DW2 Milord, evidence of DW2 Milord.
Who is delivered to Kansu?
Kansu.
Kansu.
Kansu Sen. Yeah,
Kansu.
various নাম পাই যাবা। Page 30, 1997 voter list. Here is Milord. Father name appear, mother name appear, brother name appear, and Milord.
It's not even legible. How have you exhibited this page 31? Total list of which year?
1997 Milord. In the record, Milord available, this voter list. Exhibited document. Milord. Yes, exhibit number 6. Milord.
Who was there? Nurul.
Yes, Nurul Haq, Lokman, Rabia Khatun, Nurul Haq, Meher Ali Nurul, Alia Khatun, Meher Ali. Exhibit 6 Nurul. Process.
And who are the other two names?
Milord.
After Nurul and Rabia, who are the other two names?
Rabia, Meher Ali,
Who is Meher Ali?
brother Milord.
Why his name was not there in 1989?
89, his age is shown in 22 Milord.
No, one brother is then Sheikh. Where is Sheikh gone?
Oh,
Kansu Sheikh?
Kansu Sheikh is 19, voter list of 1989.
No, in page 31, he is not there.
Yes, he's not named in the year Milord, but subsequently Milord, page 32 Milord, voter list of 1997. His name appear here. Shifting written is তখন পরিচিত আগে থেকে এটা শিখি।
33 is which year?
33 or 97 voter list.
No,
Exhibit 7
No, 31 is which year then?
or 37 Milord,
31.
97.
Both are 97.
Yes, both are 97. House number difference Milord. Due to marriage Milord, my marriage took place and subsequently constructed separate house Milord. Village is same Milord, same block.
Kansu Sheikh and
Kansu,
Jahana Khatun.
yes. 2005 voter list Milord, page 34. Nurul Haq, Lokman, Rabia Khatun, Nurul Haq. Mother, father and mother.
Yes.
Page 34 Milord.
34 we have seen.
Awesome.
2005.
Yes. And next Millard, 37. Council Sec,
Epic.
yes.
You're Epic.
Electro photo
No,
identity
Epic
card.
of your
is the
brother.
Nurul Council Sec. Page 38, Millard. Page 39, kindly say, Barnacular was Saleh Khatun Nurul Haq School Certificate.
Yes, please read.
Page 39. Saleh Khatun, Pita Nurul Haq, Gao Works Sand Block, Thana Dokin Shalmara, মহকুমা ধুবুৰী, জিলা ধুবুৰী, চেণ্ট ব্লক শান্তিনগৰ LP স্কুল পঢ়িছিল। 1992 চনৰ ডিচেম্বৰ মাহৰ 31 তাৰিখত এই বিদ্যালয়ত তেওঁৰ শিক্ষা শেষ হ'ল। তেওঁ এই বিদ্যালয়ৰ 4ৰ্থ শ্ৰেণী শেষ পৰীক্ষাত উত্তীৰ্ণ হৈছে। বিদ্যালয়ত থকা কালত স্বয়ংক্ৰিয় জানিব বয়স স্বয়ংক্ৰিয় ছাত্ৰ ছাত্ৰীৰ জন্ম তাৰিখ 31/12/1978।
Which school is this?
Sand Block Shantinagar LP School. Middle portion. মহকুমা ধুবুৰী, জিলা ধুবুৰী, চেণ্ট ব্লক শান্তিনগৰ LP বিদ্যালয়ত পঢ়িছিল।
In 1992, you were in class 4.
Yes. As per school admission register, her date of birth 31/12/1978.
Mm-hmm. 78.
Okay, we'll come within 5 minutes.
School certificate, page 39 Millard, already seen Millard. Her date of birth is 31/12/1978 Millard. Thereafter, she has exhibited one marriage Kavinama Millard. Page 41. Exhibited Millard. Here is Millard Saleha Khatun. Here Millard Haq, Sand Block. Date of registration 2/12/1995.
What is the date of this? Kabilnama?
Kabirnama date of marriage, the registration, 2/12/1995.
Where do you get?
It's 41 Miller, right column Miller. Bangalore.
2/12/95.
Plus, page 44 Miller, 1 certificate. And this certificate, exhibits are no, author of this certificate not examined. Main linkage certificate is school certificate in this case. Where our father name is here, I see the school name here. And this certificate was examined, I don't know. The proof certificate. Evidence in sheet of the DW1 Miller, page 67.
Page?
Page 67. Evidence in sheet of the certificate of DW1. Saleh Khatun, wife of Hamid Ali, daughter of Nurul Haq. Here is Sarah 1 Miller. He has mentioned as Griffin Miller. Brother, sister, brother, and others in the children of Miller. There are 2 Miller regarding.
Yes.
Am I reading?
Yes, please.
Page 67. And Saleh Khatun, wife of Hamid Ali, daughter of Nurul Haq. Alias Nurul Haq, Nur Hussain, vegetable for years by religion and preference. Sarah 1. Yes, my grandfather name is Lokman Ali, Lokman Sheikh, son of Gopal Sheikh, and he has total 7 children. 4 sons, namely Nurul Haq, office father, Sanwar Ali, Anar Ali, Haji and Rajiv, alias JB Rajiv, alias Rajiv Ali, and Ahmad Ali. All are sons of Lokman Sheikh and 3 daughters, namely Baila Khatun, Rukia Khatun, and Shokina Khatun. And my father had 8 children. That is Kansu Sheikh, Meher Ali, Shomer Ali, Nasiruddin, Malajar Khatun, Saleh Minasima Khatun, Navida Khatun, and I have got 5 children. Namely, 20 grandchildren. Apparent visitors. I am an Indian citizen by birth. He is born at Jodhwar, he has 14 months, district Huburi, Assam, where my father Nurul Haq, and Nurul Haq, he has also son of Lokman Ali, Lokman Sheikh, was a resident having the right of voting under which was closely to Shalmara, and later on, the state of village and blocks, and I have used. I'm married to Hanif Ali, son of Badar Kubir of village and blocks under PS Pokirba. Dhuburi in the year 1995. In this connection, one registered marriage Kabinama submitted. Which is paraphrased. I, Saleha Khatun, daughter of Nurul Haq, was the teacher of Stanley Kanti Nagar LP School. And she read up to class 4 and she is a good certificate by date of birth has been clearly mentioned 31st 12/1970. The copy of this book and she is two. And that my grandfather's name is Lokman Sheikh, son of Gopal Sheikh. Is included in the NRC 1951 along with my grandmother Rongbahar Khatun, wife of Lokman Sheikh, office father Nur Hussain, and my office uncle and aunt under house number 32, union number 11 at village Hazrat Dewanipara, previous place of residence Miller. And that my father was born in the year 1941. In this connection, certificate of NRC issued by IC South Salmara PS is submitted so and so. Para 5. After 1951, my family shifted to village Bhauribita from village Hazrat Dewanipara under Swaiga PS and resided thereon. And that my father's name Nurul Haq Ali, son of Lokman, along with my grandfather Lokman Sarkar, son of Gopal, grandmother so wife of Lokman, office uncle Anar Ali, son of Lokman, mother Rabia Khatun, wife of Nurul Haq, appears as a voter in the electoral 1966-1970 under the same house number 21 at village Bhauribita, subsequent place of residence, shifting area under the same 56 Swaiga LLC respectively. Certified copy of the electoral room 66-70. 6 number paragraph. That my father's name Nurul Haq, son of Lokman Haq, mother name Rabia Khatun, wife of Nurul Haq, and brother Kansu Sheikh appears as a voter in the electoral roll so and so. Zorarsor Part 3 under house number 36, South Salmara LLC. My parents shifted here from the village Bhauribita to village Zorarsor after 1975 and staying there for a few years and again shifted to his house to village Sand Block. In the electoral 1989, my mother's age is wrongly recorded as 40 years instead of his actual age 46 years. The certified copy of the electoral 1989 is submitted and electoral rule 1979 submitted so and so. That my father after the year 1990 again shifted their house from village Zorarsor to village 9 Sand Block due to erosion, and the name of my parents Nurul Haq, Rabia Khatun, and another brother Meher Ali appear as voters in the electoral 1997 house number so and so, South Salmar LLC. As my father age is wrongly mentioned as 60 years instead of actual age is 56 years. And mother's age is 45 years instead of actual age 56 years. The certified copy of the electoral 97 is exhibited. Para 9. That my brother Kansu Sheikh, son of Nurul Haq, shifted to village Sitalkati under South Salmara PS, where his name appears as a voter in the electoral 1997 under South Salmara LLC along with his wife Shahanara Khatun, house number so and so. That my parents' name Nurul Haq and Rabia Khatun appears as a voter 2005 under South Salmar LLC, house number so and so, Sand Block, copy of electoral 2005 is submitted, exhibit 8. That I, Saleha Khatun, daughter of Nurul Haq, is a recorded pattadar of a plot of land at village Sand Block along with brother Kansu Sheikh and Dia and 3 other sisters, Malika Khatun, Nosima and Nazira, fight order dated 23/3/2009 by ASO, Assistant Settlement Officer, Bogribari, Athani Circle. That my brother Kansu Sheikh, son of Nurul Haq, is a registered voter at village Chirakhua Part 2, having voter ID card issued by Yaru South Chalmara LSC. It may be mentioned here that the village Chiralkati is in adjacent to the village Chirakhua Part 2, and due to erosion of his brother again shifted to village Chirakhua Part 2 from village Chitalkati, and hence in the voter ID card my brother's village is mentioned as Chirakhua Part 2 instead of Chitolkati. The copy of voter ID card is submitted. That my father Nurul Haq, Nur Hussain indicate one and same identical person. That is the father of the OP. And the Lokman Sheikh, Lokman Ali, Lokman Sarkar also indicate one and the same identical person. That is the grandfather of the OP. That during verification, electoral roll, I have been wrongly identified as a voter, as a
Doubtful vote.
as a voter in the electoral 1997 at village 9 Chan block under South Chalmara LSC, but I am an Indian citizen by birth. Copy of electoral roll 1997 is submitted exhibit here. That neither myself nor my parents or grandparents came from Erstwhile East Pakistan or Bangladesh on or after 1/1/1966. That the contents made herein from para so and so are to the best of my knowledge, belief, information, nothing is conceived herein. Next Millard page, cross part Millard. Page 71. Vernacular is page 72. Vernacular is I was born at Zorarsor, PS Fakirganj. My grandfather name is Lokman Sarkar, alias Sheikh. Father name is Gopal Sheikh. Grandmother name is Rongbaha. Grandfather belongs to Hazrat Dawanipara, PS South Chalmara, a later Bhauria Vita actually, Gata Goraimari Soigao. Later on, my father shifted to Bhaurivita, Goraimari, Soigao, and thereafter to Chaurarsor. Thereafter, all are shifted to Sandblock village. I got married with one Hanif Ali, son of Fakir. My husband at first married Monijan Bibi, and later he got married with me as second wife. I was got married when I am 17 years old. I studied up to class 4 at Sandblock Santinagar LP School. We are brother and sister, 8 brother and sisters, namely so and so, so and so, so and so. My father name is Nurul Haq, and there are 4 brothers and sisters, namely so and so, so and so, so and so. Aunt's name is Baila Khatun, Rukia, Sokina. My mother name is Rabia. Father's name is Kosim Sheikh. My mother's father home at village Goraimari. I have 4 sons and daughters, namely so and so, so and so. My husband is doing business. We have no parental and we are residing with brother. I'm married solemnized with Kabin Nama. This evidence may not rebutted by the state authority matter.
This
And-
evidence,
Millard.
this is the
He-
cross.
Yes, cross part Millard. Cross part and evidence in Chief Millard are not rebutted by the state reference, state authority.
No rebuttal evidence.
Yes. And that is admissible Millard as per Abdul Khalik judgment Millard. I am relying Millard.
But this court has held the aspect of non-rebuttal of evidence. Simple by non-rebuttal, it will not become acceptable.
It is admissible as per.
Admissible.
Yes,
Admissibility is different
yes.
matter, acceptability is different.
That is the
matter.
other matter.
Admissible evidence.
Yes, admissible evidence.
But to accept it,
Yes.
you have to overcome the test of section 9.
Page 74 Millard, DW2 Kansu Sheikh, whose name is appear along with the father, mother Millard in voter list of 1985.
Here in this case, we have found cross. there are few cases where even cross-examination is not there.
Yes,
It
Milord.
will not mean that whatever you say will be the sacrosanct truth.
That is the duty of the state authority,
Say, you know,
to
if
cross
they don't,
the
you know, if they don't
proceeding.
cross,
Yes,
like in a civil proceeding, unrebutted evidence
yes,
may amount to an admission.
admission, yes.
But here it's slightly different. Because it has to be has to have a sync with the scheme of the act.
Yes. DW2, my lord, page 74.
74.
Yes.
What is 74?
Evidence of DW to counsel said.
His brother.
Brother, whose name appear along with the father and mother, my lord, in the voter list of 1985. I am reading.
Yes, please.
I, Kansu Sheikh, aged about 48 years, son of Nurul Haq, alias Nural Haq,
He is DW what?
DW2, my lord. I, Kansu Sheikh, aged about 48 years, son of Nurul Haq, alias Nural Haq, Ali, alias Nural Hussain, resident of village Chirakwa, Part 2, PS Fakirganj, District Duburi, do hereby solemnly swear so that the OP Saleha Khatun is my own sister, and that my grandfather's name is Lokman Sheikh, son of late Gopal Sheikh, and he had 7 children, 4 sons, namely Nur Hussain, Nural Haq, Sanwar Ali, Anwar Ali, baby alias Rajiv Ali, Rajab Ali, and Ahmad Ali. All are sons of Lokman, and 3 daughters, namely Baila Khatun, Rukia, and Sokina. And my father had 8 children, that is Kansu Sheikh, I myself, Meher Ali, Somer Ali, Nasiruddin, Malika Khatun, Saleha Khatun, petitioner Miller, Nosima Khatun, and Nazira Khatun. And OP have got 5 children, namely Moina Khatun, Morjina, Mozilla, Saidul Islam, Samidul Islam. OP's my mother name is Rabia Khatun, wife of Nurul Haq. Para 275. Please. That I am an Indian citizen by birth, and the OP is also an citizen, along being born at village Jaurarsar, PS Fakirganj, District Dhuburi, Assam, where my father Nural Haq, so and so, late Lukman Sheikh, Lukman Ali, Lukman Sarkar, Lukman, who is the father of OP, was a resident having the right of voting under 22nd South Shalmar LSC, and later on shifted to village Sen Block, and the OP have been married to MD Hanif Ali, son of Badr Fakir of village Sen Block under PS Fakirganj, in the same district, Dhuburi, in the year 1995. In this connection, one registered Kabinnama of her marriage is submitted. That my sister OP Saleha Khatun, daughter Nurul Haq, was a student of Sen Block Shantinagar LP School, and she read up to class 4. And in the school certificate, my date of birth has been clearly mentioned as her date of birth. Here, my wrongly. My is wrongly her, actually. Her date of birth.
Let us see what is the vernacular.
Vernacular, para 3. Vernacular is Assamese.
Is it vernacular or is it in English?
This is the type of similar type.
Oh, that means cut paste.
Yes, yes.
It's cut paste.
3, para 3.
Cut paste.
Cut paste. And that is to certificate.
Proceedings,
Yes, yes.
evidence has been
Yes, yes, yes.
cut and paste.
Yes, yes.
And in the school certificate, my date of.
Copy paste me.
Okay, her, any.
Copy paste.
Or is correction, not cut paste, copy paste.
Copy paste.
Okay, we accept copy paste.
Copy paste. Sometimes we also copy paste. That's why sometimes. But that my grandfather's name is Lokman. Millet here is almost same with the DW1 millet, just cross part millet. Here is cross Cross part is specifically. Page 83 million. Cross part.
Eighty-three.
Yes. OP is my own sister. We have 8 brothers and sisters. Elder one name is Malika
Eighty-three is the cross
Cross part.
of Kansu.
Council. DW2.
Please read.
OP is my own sister. We have 8 brothers and sisters. Elder one name is Malika Khatun, 50 years, Kansu Sheikh, me, 48 years, Meher Ali, 45, Saleh Khatun, 40, Somer Ali, 35, Nasiruddin, 30, Nazima Khatun, 25, Nazira Khatun, 22. My father name is Nur Hussain alias Nur Hussain. My mother name is Rabia Khatun, aged about 65 years. OP got married with Hanif Ali of Sand Block village in the year 1995. OP has 5 children. OP's husband, first wife name is Moziron Bibi, and I do not know their children. OP passed LP school. I was born at Bhauri Vita village, and later we shifted to Jhaurasar, and OP was born here. Now we are residing at Sand Block. My father has 4 brothers and 3 sisters, namely so and so, so and so. My mother name is at Bhauri. My mother, whom is at Bhauripara, Soigao, Bhauri Vita actually. My maternal grandfather's name is Kasem Sheikh. My sister is not now father's land. It is not true that OP is a Bangladesh.
My sister is at now. What is the last line? What is the last line? My
So,
sister is at now.
Yes, my sister is at now father's land. Here is in Assamese, page 84.
Yes.
More Soigao, নানার নাম কাছে
Matit.
আর দেউতার মাটির ভন্তি বর্তমান আছে in vernacular page 84 bottom. দেউতার মাটির ভন্তি বর্তমান আছে।
Now space. On the path.
হয়তো নহয় যে OP বাংলাদেশী।
Okay.
Page 85 DW3 headmaster.
Who gave that school certificate?
Yes, minute.
Headmaster.
Yes, I am reading Miller. The deposition of the DW3 Miller. My name is Abdul Khalek Mia. My father name is late Hasim Ali Munshi. I am a resident of village Adimaluti, Part 2, Police Station, Fokirganj, District, Dhuburi. Occupation LP School, Headmaster, Head Teacher, South Block, Santinagar LP School. Exhibit 2 is the certificate which is issued by me. Exhibit 2.1 is my signature as head teacher. Exhibit 2 is given in the name of Saleh Khatun, daughter of Nurul Haq, Sand Block. OP studied up to class 4 and Exhibit 2 is issued for this. I bring my ID card. Today I bring the admission register. On page number 13, serial number 28, OP name is available. Exhibit 2 within bracket 3 is the office name availability register, and exhibit 2.4, exhibit 2.5 is the certified page. Exhibit 6 is my signature. I issued exhibit 2 on 2/1/2016. I have been working as headmaster in this school since 1983, and it is become government school from 2013. OP took admission in 1985, and in 1992 OP passed class 4. At that time, this was not Gov school. At that time, this is the Bansar school. Exhibit 2.3, I have certified as head teacher. At 1979, I was not in that school, and Lashkar Ali was headmaster in this school that time, my lord. In this school, the present headmaster joined in 1983. And now coming to impugn order, page 88.
Type code 83 na hidden. In the type portion, 1983 has not come. Of DW3 cross-examination.
DW 283,
And
DW
in the type copy,
translated manner.
translated type code 1983 has not come, that part.
Which one, Miller?
You have just read 85,
Ah.
isn't it?
Page 85.
85.
Cross part.
Hmm? The translate, this is the type copy.
Oh, yes.
Translate- that,
I extra translated by lot Miller.
last part has not
Oh,
come.
the last part is not. Sorry, Miller. Oversight.
Second year, I wrote it, wait.
No, yeah, cross part is left off.
No, this is cross only.
এক্সিবিট 2 খন 5/1/2016 তারিখে ইস্যু করেছি।
Across part has not come.
মিলাট এক্সিবিট 2 খন এটা করেছ
Chief,
এটা নাই নাকি?
No, cross part to
this was not on affidavit. This was directly in the court. Cross part is not.
Cross is not in type code.
Anyway,
Even this part, chief has not been typed out. Exhibit 2.6 more, so that part has not come. Why have you done half?
you can read it.
মিলাট বার্নিকুলার পেজ 87। এক্সিবিট 2 খন 5/1/2016 তারিখে ইস্যু করেছো। 1983 সনৰ পৰা
No, you have typed out.
Yes,
This part is there, but it's not discernible.
yes.
And last part, but you have not typed out. 1983 part.
Yes. উক্ত স্কুলত 1980 চনতে হেডমাষ্টাৰ হিচাপে কাল যোগদান কৰিছোঁ। 1979 মই স্কুলত মই নাছিলোঁ, তেতিয়া লস্কৰ। This part also here is Milot at 1985 bottom. At 1979 I was not the school, and Loskor was a headmaster of this school.
Where is that 1983? Yes.
Last night, yeah?
Exhibit 2.1 খন মই হেডমাষ্টাৰ হিচাপে চাৰ্টিফাই কৰিছোঁ, যদিও মই উক্ত স্কুলত 1983 চনত হৈ হেডমাষ্টাৰ হিচাপে কাম
হিচাপে কাম কৰিছোঁ।
কৰিছোঁ।
যোগ কৰিছোঁ।
যোগ কৰি that 83 is not there.
Yes. I became the working as a headmaster in the school 1983 আছে তো here my lord the bottom to top my lord 1 2 3 4 fourth line my lord I have been working as a head teacher in this school since 1983
But that is the last line almost.
Oh,
You
yes.
cannot alter
Yes,
the
yes.
sequence.
Yes. Last line not translated my lord. Back for the I mean, the middle line to night. Translate one.
Yes, no.
Next, my lord, coming to imprint order is space 88.
Page?
88. Double out. I'm reading Miller.
Yes.
This, the case against the above named OP in brief is that the OP has been suspected to be an illegal migrant foreigner and on the basis of report submitted by LBO. Most important, Miller. The report is almost entire blank, Miller. It is a format, a ready-made format, Miller. Only written name and husband name, Miller. And nowhere mentioned that the OP, the petitioner is entered into India after 1971. There is no any stream. না, ওই যাও। Inquiry report কোথায় আছে? আসুন। Page 45, Miller. Report of the LBO. Entire blank below, here is only Saleh Khatun.
But
And-
that is not the challenge.
Challenge Miller.
Your challenge is with the opinion.
In the written statement, Miller.
No, you see the prayer.
Yes.
You have not challenged the reference.
A reference in this case, Miller, I have challenged the reference.
You have challenged the opinion.
Opinion including Miller.
No, read the prayer. Page 17. Initiation of the proceeding is not the subject matter of challenge. If it is there, kindly point it out. We did not see. You're only,
I believe it was contended from the other side that report, those columns were blank because no information could be provided. And I think on that basis,
That means,
reference was-
Miller, the inquiry officer never visited the house of the petitioner, Miller. I am relying on judgment, Miller, Supreme Court, Miller, where
Yes, seen.
yes, a clearly stated, Miller, in the Supreme Court, Miller.
there is one part, you have challenged that inquiry report, 27/9/97, that is checked there. You have not.
My further prayer, Miller, the direction shall
that
be to
inquiry
to
report is
conduct
the-
fresh inquiry, Miller. Page 18, Miller. Alternative prayer is here, me to conduct fresh inquiry. Giving opportunity and for
No, we'll have the version of response of Mr.
Yeah.
Payang and others.
Miller, in this case, Miller.
You make your submission.
DW1, DW2 and DW3, Miller. I have gone through the judgment, Miller, opinion, Miller. And that learned tribunal did not give any finding on the evidence of DW2, Miller.
Kanshu,
So, Miller.
Kanshu Singh,
Kanshu Sheikh.
our brother,
Yes, brother.
to be our brother.
Yes. And on this count, Miller, I have to relying on judgment, Miller, of this honorable court.
Yes, please.
Jamila Khatun. And this honorable court remanded the back to the tribunal and to give fresh opinion on this, on the same matter.
Citation, please.
Yes. WPC 48243. Recent Millet, 11, 11,
WPC
2024.
4824.
No Millet, 8243,
8243 of
18.
18. Name
Jamila Khatun,
Jamila.
yes.
Z-I-Z-A.
Jamila, Jamila Khatun, alias Jumila Khatun. Millet,
It was, it's a recent decision,
Yes.
not reported, not yet reported.
Yes, not reported.
Then kindly give,
11/11/2024. Millet.
oh, 24,
Yes.
might have been reported also.
What has been stated here?
Stated here, Millet, here in para 4 of the imperial opinion.
Which para?
And,
Date 11/11/24.
Para 6 Millet.
11, 11, 20. Para?
Para 6.
Please read.
Thus, the learned member Foreigners Tribunal 2 Nalbari has failed to discuss the evidence of 1, DW1, DW3, 5, and 6, and the said learned tribunal also failed to discuss the exhibit 2 to 6 and 8 to 13. Under the circumstances, the court is of the unhesitant view that the learned tribunal has not properly appreciated the documents and evidence adduced by the petitioner, and as such the impugn opinion dated so and so is held to be unsustainable on the facts in law. Therefore, the impugn opinion dated so and so passed by the learned member Foreigners Tribunal Nalbari so and so is hereby set aside and direct that the matter be remanded back to the said tribunal, which would be required to be reappreciate the evidence and give a fresh opinion in accordance with it. Yeah. Very true, yeah. Amina Khatun.
Let us see how your contention is justified
Yes, Millet.
from the impugned order.
Yes, Millet.
Let us see the discussion part.
Yes, the discussion part is,
Court of action is open if like on these lines, this appreciation is not proper.
yes, up to page 90, Millet.
Even facts-
And now the decision and reasons, Millet.
Page 18.
Page 90, Millet, bottom, Millet. Now the decision and reasons.
9th page.
90. Bottom, Millet. Para 1 Millet, here is exhibited 1 Kabirnama reveals that the marriage between the OP and Hanifali was solemnized on 2/12/95 and registered the same by the district Qazi on 35/17 by putting signature. It is clearly indicates that the marriage was performed 2/12/95. The registered the marriage by the Qazi after 22 years. The OP first appeared before the tribunal on 12/7/17 after receiving the notice. So it is crystal clear that the submitted Kabirnama so and so is manufactured doubtful document and submitted the same to defend the proceeding against the OP. The registered Qazi did not call for to prove the exhibit 1 marriage Kabirnama. Here OP failed to prove her linkage with her father or husband through the Kabirnama. Exhibit 1. The OP certificate, a GP certificate issued by the secretary, Fulkatari GP on 9/7/15 in the name of OP where no official memo number so and so. I am not relying this exhibit Miller. Exhibit 2, school certificate, page 91. Exhibit 2 is the school certificate issued by the headmaster Abdul Khalek Mia, DW3 of Sen Block, Santinagar LP School on 5/1/2016. To OP, Salaya Khatun, daughter of Nurul of village Sen Block, wherein the date of birth of OP is shown as 31st/12/78. The headmaster of the school appeared to prove the certificate and SDW3 during his cross-examination deposed that since 1983, he has been serving as a headmaster in the said school, and in the year 2013, the school has been provincialized by the government. As a headmaster, he DW3 certified the admission register of the school from 1979, but in that time, he was not serving in the said school. At that relevant time, Lashkar Ali was the headmaster of the said school. Moreover, in the exhibit 2, the national emblem is embossed at the top may not be accepted as a valid and acceptable document. Such improper use of national emblem of the India by renders the documents is inadmissible in law, in evidence. So exhibit 2 is wholly redundant, being found inadmissible. Here OP failed to prove her linkage with her father or with husband through the school certificate, which is printed and manufactured at Ampony Printing Press, Dhuburi, as written in the Swenson. From the above observation, it is crystal clear that school certificate, that is exhibit 2, is a doubtful and manufactured one and submitted by the OP for establishing link with her father. Here OP failed to establish link with her father in absence of any corroborative evidence documents, that is the exhibit 2 cannot be accepted. Exhibit 3, copy of NRC Miller. Exhibit 4/5 is the electoral rule of 1966-70. About DW2 Miller. There is no any finding.
It's not that it's not been discussed. If you come to page 90.
Hmm.
Page 90,
Yes, only discussed Miller.
discussed.
Yes, only discussed, but did not give any finding Miller. Not discarded Miller. Not discarded by the tribunal. Evidence of DW2.
That reason.
Hanif Ali is the name of your husband.
Yes.
The Kabinama was discarded because of late registration. That is what,
Miller.
so that is the reasoning of the tribunal. People late registration.
Yes. Today, my lord, as per central government and notification, my lord, allow the all persons to register post marriage, my lord. No, happen, Robert, to wait at
That's all?
No. No.
Anything more?
Yes, my lord.
Anything more?
Yes, my lord, regarding blank inquiry, my lord. I am relying on judgment, my lord, 2022 4 GLT 102, my lord, Amina Khatun versus Union of India, my lord. Para 6, 7, 8, and 14, my lord. Relied upon the
Name. Name.
Amina Khatun.
2012, 22.
Yes. We are relying upon the para 98 of the Muslim model judgment, my lord. And similar facts with the petitioner's case.
Era?
Para, my lord, 6, 7, 8, and 14. 6, my lord, I am reading.
Proposition?
Proposition মানে blank inquiry. না, না, কোনো করেছে না।
Yes, please.
Para 6, my lord. In the EROS report, which is based on the LBS report, my lord, similar with the petitioner's case, my lord. Some doubt has been expressed about the citizenship of the aforesaid person. However, when we see the LBS report, we have noticed that entire format is blank, except the name mentioned as Amina Khatun, wife of Ismail. Here is in this case, my lord, Saleh Khatun, wife of Hanif, my lord. Others part is entered blank, my lord. Daughter of Ismail. As regards the various other particulars required to be filled up, there is nothing mentioned except the word absent or top of the format. If the basis of the doubt on the citizenship of the person is based on LBS report, we are of the view that since LBS report is devoid of any particular or any finding or for that matter any remarks or observation, the said reference cannot be said to have been made after proper implication of mind. In this case, my lord, entire inquiry report, my lord, LBS report, police report, all are blank, my lord, and ready-made format is filled up. Para 7, my lord. In the Muslim Mundal's Supra in full bench of this court observed that fair investigation and fair trial is one of the basic fundamental rights of a person, and it has been also observed that though investigation need not be detailed or an exhaustive one, keeping in view of the nature of the proceeding of the before the tribunal, the reference by the referral authority cannot be mechanical. The referral authority has to apply his mind on the materials collected by the investigation officer during his investigation and make the reference on being satisfied that there are grounds for materials for such reference. Referral authority, however, need not pass a detailed order recording his satisfaction. An order agreeing with the investigation would suffice, and the referral authority, while making reference, shall produce all the materials collected during the investigation before the tribunal, as the tribunal prima facie required to satisfy itself about the existence of the main grounds before the issuing notice to the proceedee, as mentioned in para 97, 98 of the aforesaid decision, my lord, Muslim Model case. Here in this case, my lord, in the notice, my lord, where And there is no any ground, my lord, provided to the petitioner, and also not mentioned the stream, my lord. The petitioner is entered into India in between 66 to 71 or after 25th 1971, my lord. Para 8, my lord. In the present case, we have.
Now, Mr. Ahmed, once the reference reaches the tribunal,
Yes.
is the tribunal again required to look into the reasons for sending the reference, or is the tribunal required to issue notice?
A tribunal must be satisfied on the reference referred by the referral authority. That there is a ground, my lord, there is a
No,
proper.
is there a
proper
requirement, is there an
investigation.
requirement in the statute that the tribunal has to first apply its mind to the referral order and then proceed in accordance with law?
The inception.
Yes. Yes, my lord, in the section rule 3 of the
That's- Comes to the conclusion that the reference.
in this connection, my lord, I am, yes. In this connection, I am relying on Supreme Court judgment, my lord, where 34, 35 paras, my lord, where clearly stated there. As some officers entered the house and knocked the door, my lord, asked the procedure to produce the
No,
document.
those observations are out of the context. Those observations has clearly
Regarding the inquiry part.
clearly overlooked the observation of a constitution bench in the Sarbananda Sonwal. You are referring to the other judgment. Sarbananda 86, 83 all have been all overlooked. See, personal liberty is very correct. You cannot go and knock at
Yes, yes.
somebody's door.
Yes.
But that is a different aspect. The aspect which we are asking,
In this case, my lord, kindly see the inquiry report. Where from the source, my lord? Where from the source, my lord? That she is a Bangladeshi, she is a suspected person. There is no any source, my lord.
Only one point I'd like to, this is a overrule. In fact, this argument has already been overruled by this honorable court in the subsequent judgment. So this may not be argued again and again. An overrule argument.
no, the constitution bench is there. We cannot, that part, no, he is making one, we are on a different footing. Is the tribunal, is a duty cast upon the tribunal to first apply its mind at the inception, which my brother has said, the expression he has used, at the inception to consider as to whether there are materials to make the reference, or is the reference made in a very mechanical manner before issuing notice. Is it incumbent upon the tribunal? Does the law or does the statute provides for that? Or does the statute say that that is within the domain of the referral authority? Once the reference come, the tribunal has to issue notice.
That is not true. As per Muslim model.
Because opinion does not mean that opinion is only of being a foreigner. There are many opinions where on being satisfied with the documents,
Yes.
Indian citizenship is declared.
Yes.
So it doesn't mean that all referral has to end up in a manner in one direction only. There can be other directions. So at the inception, I do not think that tribunal, without even giving a chance to the proceedee, will make up his mind.
The tribunal
Such conclusion will be arrived at only after giving you an hearing. You may be
tribunal
You
also cannot be mechanical.
Proceeding may be successful
Hmm.
in proving that yes, no, the referral is bad. I have these materials. Only because of lack of material referral made, can there be a ground for challenging the opinion?
A referral authority and a referral authority cannot be mechanical manner. Fair investigation.
show us
fair-
that.
That is the
Show
fundamental rule.
us that
Right.
part.
Yes, that part. And a tribunal also cannot be mechanical manner.
Tribunal
In this
cannot be-
case, my lord.
Tribunal cannot be mechanical.
Yes.
That tribunal is a quasi judicial authority.
Quasi-judicial.
And it has to abide by the principles of natural
Yes,
justice.
principles of natural justice.
Those are sacrosanct fundamental.
Yes.
But whether tribunal has to satisfy itself on the requirement of issuing notice, that you have to answer. We'll come back at 2 o'clock.
Yes.
Yes, miss.
My lord, one question raised, my lord, whether the tribunal must satisfy before issuing the
Notice.
notice, my lord. In this regard, my lord, full bench of this honorable court, my lord, Muslim Mundos case, para 81, my lord. I am reading this paragraph, my lord.
Please give the citation.
My lord. 2013 1 GLT
2013,
1 GLT
1 GLT,
809,
para.
paragraph 81, my lord.
Please read.
Yes. The apex court in paragraph 60 of the said report also opined that since the tribunal in the notice to be sent to the proceeding is required to set off the main grounds, evidently the primary honors in relation thereto would be on the state, and once the tribunal satisfied itself about the existence of the grounds. Look, in this case, my lord, in the reference, my lord, in the inquiry report, my lord, entire inquiry is the blank, my lord, as such, on the basis of such reference, my lord, the tribunal, on what basis tribunal satisfied and issue the notice, I don't understand, my lord. Yeah, the burden of proof would be upon the proceeding. In the Sarvananda Sonal 2 Supra, the apex court, therefore, has held that the state is not required to adduce evidence first to prima facie satisfy the tribunal relating to the existence on the ground on which the reference is made. What the apex court has said in paragraph 60 is that the primary honors in relation to the existence of the grounds to the satisfaction of the tribunal would be on the state, meaning thereby that the grounds on which is proceeding is suspected to be a foreigner must be reasonable and relevant to the issue of foreigner. For instance, if the ground taken in a reference proceeding suspecting a person to be a foreigner is that he wears a particular dress or is having a particular feature, such grounds cannot be said to be reasonable having any nexus to the issue of foreigner, and hence the tribunal and necessarily would not issue any notice on the basis of such grounds and reject the reference at the threshold. In this case, my lord, tribunal ought to have returned the reference to the referral authority to conduct fresh inquiry, my lord. In this case, my lord, the tribunal also has not done and passed the impugn order, my lord. And my prayer will be, my lord, the matter may be remanded back to the tribunal for decide the fresh and give opinion on the DW2 evidence of DW2, my lord. Whereas, my lord, the tribunal did not give any finding on the DW2 reference in the evidence of DW2. And furthermore, my lord, the tribunal, this honorable court may be directed the tribunal to remand the reference to the referral authority for conduct the fresh inquiry, my lord.
First, you have said that it should be remanded to the tribunal to appreciate the evidence of DW2.
Yes.
Then you say that no. The
Alternative prayer, my lord.
tribunal should
Alternative prayer,
again.
my lord. If the remand back the tribunal, my lord, tribunal may be may send a remand back, my lord, to the referral authority to fresh conduct.
Let us hear the other. Yes, where is Mr. Pai? Who will submit?
Lordship, if possible, Lordship, it's more at 10:30.
We want to finish
Due
this.
to some problem, Lordship, he is left the court, Lordship.
We wanted to really, because some responses were necessary.
Yes, Lordship, and 10:30, Lord.
I'm not aware of the
10:30.
Okay, tomorrow, immediately after the motion, tomorrow, Wednesday.
Yes, sir.
But motion, see if there are old motions which you take up for disposal, this will be the first disposal item, okay? Wherever notice are required to be issued, we'll issue notice, then this will be the first item we'll have for final, the rest of the hearing, okay?
We will not bring.
There are certain motions which are also disposal, will not take up those, first disposal item, okay? Motions which are actually fresh filed here now, we have seen motions of 2023 also,
Yes, Lord. Yes.
unfortunately. Nonetheless, okay, heard Sri A.M. Ahmed, learned counsel for the petitioner, who has advanced his argument, full stop. However, some accommodation has been sought for on behalf of Sri J. Payang, the learned standing counsel, Home Department, full stop. Para, considering the same list, so accordingly, we direct listing of this matter tomorrow for further consideration. We get up. Yes, ma'am. K. Devi. Yes, madam, you're with Madam K. Devi, you are sitting. Your matter is
Yes,
with.
Your Lordship, she's in another record. She's coming. She's in foot number 9.
Yes.
The accountant lordship, they already approached to for the benefit of car lot.
Is it?
Yes.
Oh. Then we can close this.
Lordship.
Let her come.
She's coming.
Madam Burman, which is your matter? I have hearing. 18 matter.
May I pray some time, Lordship?
That was not the purpose of asking you. We asked you to come forward to do the case, not for seeking time.
My lord,
What difficulty do you have today?
not properly prepared, my lord.
You are always prepared. You need not be properly prepared. Your improper preparation is enough for us.
Thank you, thank you.
Next one goes again. 18. 18. Ah. Your item may not reach me, Madam Gorman. You can, we'll have it some other day. But next time, don't say you are not prepared.
May please, your lordship. My lord, here in this case, we have earlier submitted our written argument. Raising some preliminary question, my lord. First question is, my lord,
Just a minute.
নহয়, মই
উপায় কেন খাই এগুলো? আমি ঠিক আছে খেয়াল করি ওখানে।
দুটা আছে। Here, my lord, there are two LCR, my lord. One is Hussain Ali, son of Asadullah. That is the present petitioner. There is another Hussain Ali, son of Khalil Sheikh. These two case record. Those two records were some, my lord, there was some mismatching. Records were wrongly attached with another. Therefore, this was record was called for.
Madam, there is some development
Yes,
here.
madam.
You have to, if,
Applied for before the
then you can
government.
withdraw this.
Yes, madam. Proceed.
Okay. I have to take it as
Item number 17, a supplementary.
Just a minute, Mr.
Well,
17. Third, Ms. K. Devi, also heard presence. The present challenge was instituted against an opinion dated 4/5/2017 passed by the learned Foreigners Tribunal 10 Tubri in so and so, whereby the petitioner was declared a foreigner post 25/3/1971. Full stop. Para? Though this writ petition was instituted in the year 2017 and is pending since now, Ms. Devi has informed that hearing of this matter had taken place earlier, which however did not culminate in any judgment. Full stop. Para? The Learned Council has however informed this court that after the enactment of the CAA, there are certain developments and the petitioner has development under which the petitioner has applied for getting the benefits. Full stop. The Learned Council submits that accordingly instructions have been given to her to withdraw this challenge. Full stop. So do not object to the said prayer. Full stop. The writ petition accordingly stands dismissed on withdrawal. Full stop. The impugned opinion shall not come into the way for consideration of the case of the petitioner under the CAA.
Obliged.
Yes.
my lord, my first submission is based on the, my lord, inquiry report of the border police. There was inquiry by both the border police as well as the ERO. ERO has made the reference, my lord. In record, Lordship may kindly have a look at, my lord, page 6 of the record. Yes, in FT case 283. FT case 283.
Page 6.
Page 6 of record, my lord. Here, my lord, the enquiry officer, police enquiry officer has stated, my lord, that petitioner's grandfather is voter in 1966. There has been some documents. So he's not a foreigner. May I read it, my lord? To the Superintendent Police Goalpara border, district Goalpara, dated 25/9/2006 through proper channel. Note on verification of D voter 656 Hussain Ali, son of Asadullah, son of late Kamaluddin of village Bamundanga, part 2. Police station number 88 under 38 number LSC of Bogwan PS. Madam, I have the honor to submit the report of above D voter's nationality is that the D voter's grandfather's name is late Kamaluddin, and though his father's name is his father's name is not appeared in 1966 electoral roll, his grandfather's name is Kamaluddin is appeared in 1966 electoral roll, white serial number 176, house number 68 of village 327 Bamundanga, part 2, Satpur Balijana, PS Lokhipur of 45 Goalpara East, LSC of Goalpara district. Hence, D voter 960, D voter 656, Hussain Ali being Kamaluddin's grandson is a citizen of India. This is submitted for favor of your kind information and necessary action. This was the report by the Border Police SI K.C. Roy. So, based on these materials, there shall not be any cognizance of any case against the petitioner because as per the full bench decision, paragraph 98, the tribunal is to go through the materials and should record its satisfaction. On what basis he is to take cognizance?
Muslim Mandal,
Yes.
full bench Muslim.
Full bench judgment. 2013.
Please read that part.
My lord. Full bench judgment.
The part which requires
My
that
lord.
is satisfaction
my
to be recorded.
Full bench judgment.
Better?
My lord. May I read, my lord?
Yes.
Paragraph 98. The reference by the referral authority also can
Paragraph
be
90,
98.
98.
98. May I read, my lord?
Yes, please.
The reference by the referral authority also cannot be mechanical. The referral authority has to apply his mind on the materials collected by the investigating officer during investigation and make the reference on being satisfied that there are grounds for making such reference. The referral authority, however, need not pass a detailed order recording his satisfaction. An order agreeing with the investigation would suffice. The referral authority also, while making the reference, shall produce all the materials collected during the investigation before the tribunal, as the tribunal is required prima facie to satisfy itself about the existence of the main grounds before issuing notice to the proceeding. So this part has not been whispered at all while taking cognizance. This is my
It's an aspect of prima facie satisfaction.
satisfaction.
You are
Before
not-
taking,
you are
before
not required
taking
to
cognizance.
go deep into it's on a apparent look if you are satisfied. Now, how would that exercise be?
The tribunal is required prima facie satisfy. That should be recorded. These grounds we have satisfied. There is specific materials that the border police has inquired and found that he is not a foreigner. He is a citizen. So on what basis the controversy, there should be discussion that we cannot accept the tribunal. Why the tribunal should not accept this, my lord, report?
If there is a departure.
Yes, yes. That has not been mentioned. And there are so many judgments when this prima facie established that the reference was a mechanical reference. and to cognizance is not proper. There are so many judgment, my lord. And in the record, there are another report. There was a report of the ERO. That is also very important, interesting, my lord.
Page,
Uh,
you know.
that LBO report. That is, Annexure B, Annexure A of the format for verification by the LBO. Annexure A of the format of verification. Here the
Victor, Victor,
but
your present argument, if we examine in the context of your prayer,
well,
are we required to consider that argument?
yes,
Kindly see the prayer.
yes, my lord. That
Impugned judgment should not be set aside and remanded back by adducing evidence or press trial by adducing evidence. Alternatively, the petitioner may be given a chance to examine his mother. That is your prayer.
yes, yes. If we that prayer is allowed, my lord, will be, my lord, will
No,
be happy.
to allow that prayer, you have to make out a case that the adjudication on merits is erroneous, which is on the face of it.
My lord.
Material facts have not been taken into consideration. Irrelevant facts, extraneous consideration, factors taken into consideration. You make out a case of that nature. Evidence was there,
My
not
lord,
appreciated.
what I have submitted, my lord, based on record, that's a legal submission, my lord. That
No, legal submission, okay, but that is not legal submission what? In support of your prayer. You cannot go beyond the scope of the adjudication process. That will amount to challenging the reference itself,
my lord.
which is not, it's a different challenge altogether. You could have amended the writ petition.
My
Reference as such is not a subject matter challenge. Your challenge is confining to the opinion. We'll examine it. And you have made specific prayer that fresh trial, okay, or let the mother adduce evidence. Till that part you have considered in the prayer itself.
my lord,
The pleadings.
I have challenged the impugned opinion.
Yes.
Impugned opinion may be, my lord, bad because of many reasons, my lord. The inquiry, if it is the reference is illegal,
Then reference has to be challenged. The subsequent act cannot be illegal. You have to challenge the root if you want to challenge. There is no bar in challenging. Opinion, if you want challenge the opinion, we'll examine the correctness, the legality of the opinion.
my lord, when the tribunal has taken cognizance, my lord, in a illegal manner, in violation of the full bench decision, that is sufficient that is sufficient, my lord. When the tribunal has taken cognizance without looking into the matters available before him, is it not illegal, my lord?
No, that legality, illegality problem, question will arise.
My lord,
in the
simply
context-
I made some additional prayer that in the event of remanding the matter, my mother may be examined.
Yes.
That may not be, my lord.
That takes care of everything. That you are considered to the aspect that
That
even,
is my alternative prayer, my lord.
even the main prayer is to set aside the
A
opinion.
yes, to set aside and fresh trial. Fresh trial, man.
First trial, what? First trial is filed. You have not even asked for setting aside the reference order. Let us see let us see your case. What is your case? Let us see the evidence which you had adduced.
My lord, when the root of the case is illegal, kindly have a look at, my lord, the
We have taken note of your submission.
ERO report. ERO submitted report. The report is entirely blank and no signature.
We have
How-
already, you have
how
added,
that can be relied, madam.
you have advanced that argument. We have taken into consideration. Now let us go into the merits.
Hmm. Yeah. You can do it.
Where is the written statement? Page 21.
My lord, page 21. My lord, in the
26.
second paragraph statement has been made that he is a bona fide citizen. He is citizen by birth, and his grandparents, parents are also citizen of India by birth. Second paragraph, name of his grandparents are let Kamal Ali Sheikh alias Kamaluddin alias Kamal Devani. Grandmother let Aisha Nessa alias Aisha Khatun, who was who as a citizen of India had been living at village Bamundangra, Part 2, PS Lokhipur district, Kualpar, Assam.
You say your grandparents, parents are all citizens of India by birth.
Yes.
Kindly. Yeah.
Two copies. Two sets.
Then, my lord, paragraph 4 relates to electoral rule of 1966. Village Bamundangra,
Page.
page 21,
No, that is the list. That is
Bhuta list, my
That
lord.
is city list.
The Bhuta list of 1966 at page 39.
39.
39.
39.
39. Asadullah. Kamal Ali Sheikh is the grandfather, son
Let
of
us see the vernacular. Vernacular is at page
vernacular at in
40.
the next page
40.
40. Kamal Ali Sheikh.
1966.
66. Son of late Naibullah Sheikh. Aisha Nessa Kamal Ali.
Kamal Ali, who is Kamal Ali?
Kamal Ali, his name is shortly written. Kamal Ali Sheikh, the grandfather.
Grandfather.
Aisha Nessa is the grandmother.
Just a minute, please. Yeah, 1970.
My lord, 1970.
Page 42.
40, yes, my lord. Bhandakular at page 42. Kamaluddin, Naibullah, Aisha, Kamaluddin. 79 Brutalis is there, but certified copy could not be obtained. Vernacular copy was, abstract of the vernacular was produced. 1979 Brutalist. They are originally resident of village Mamandanga, but they for a short period 70 and 79 they reside in neighboring village Pandova under same circle, same police station. Then again 85 returned back to Bamundanga. '85 brutal is also in page 45. Vernacular at page 46. Here father's name is there, father and mother. And grandfather's name is against the father.
Okay, then
Then my lord,
79 could not procure,
79
certified copy could not be procured.
could not be
But where are
procured,
your
and
name?
vernacular has been produced.
Where is the name? Okay.
My Kamaluddin at serial number 545, grandmother at 546, father is at 547. And stepmother Tuhuran Khatun is at 548. Tuhura Khatun.
Where is the father's name?
My lord,
In page 44?
page 44, my lord, 547 serial number, Asatullah,
Asatullah is your father?
father. Tuhura is the stepmother. Tuhura Khatun. Stepmother.
Okay.
Then 85 brutalist lordship will find at page 45. The petitioner father returned back to original village Bamundanga. Asatullah at serial number 8, own mother at serial number 10, Rohimun Nessa. Asatullah, son of Kamal Devani.
What is the age? Age
My lord, in which brutalist?
in 1985?
85, my lord, here is certified to be
63. 63.
maybe may not be correct, my lord.
And
Is not
in 1979, he was 28.
28. So it is a mistake.
And in the other voter list, you have said stepmother. Where is your real mother?
Real
The
mother is
uncertified
Rohimun
copy.
Nessa.
Huh?
Rohimun Nessa is the
Where is the name of the real mother?
real mother will
In
also find
79.
at page 45.
No. in
Serial number.
No, in 44, in 79 voters list.
79 brutalist.
Mother is not there.
Not there. Stepmother is there, Tuhura Khatun.
Stepmother, but why your mother's name is not there?
Mother, Rohimun Nessa, my lord, in 85 brutalist, age is shown. But mother was not married, I think, at that time with father. Only stepmother, Tuhura Khatun is there.
How can you say? Your father is 63-year-old.
No, that is wrongly recorded. My lord, considering the age mentioned in 1979 brutalist, his father was that time 28 years. How that can be? It's wrongly recorded. This age is not correct.
Okay, next.
Then my lord, voter list of 93. It's not
Right.
certified copy at vernacular starts at page 48.
Why no certified copy?
They are unable to collect as I think are not provided.
Who is there in 93?
Here, mother is there.
Serial?
Rohimon Nessa,
Serial?
serial 383.
383. And where is your father?
Father's name, as per their contention, father was mentally sick for some period and therefore not listed in the voter list.
And other members? The
Other member,
Stepmother,
stepmother is also not there.
mentally sick.
Stepmother is also not there. But present proceeding is with mother.
Is he
In the
there?
2015 voter list.
Hussein Ali,
Yes, in 2005 voter list.
2000?
2005 voter list at page 52.
And this Rohimon Nessa is the wife of Osman
No, daughter of Usman Ghunim. Petitioner's mother started to reside with her maternal grandparents, and therefore mother was listed showing the name of grandfather, maternal grandfather,
Husband's name is not written.
not maternal grandfather.
After marriage,
Hussein Ali, but Hussein Ali against his name, his father's name is there. Asadullah Sheikh.
no, we are on page
Page
48.
52,
We were on page 48.
48.
If you project
yes,
this Rohimon Nessa to be your mother,
48.
there is no mention of your father. You say
Yes.
father was mentally ill. Mentally ill doesn't mean that his name will not appear in the voters list. He may not go for voting.
My lord,
Explanation is
what
very,
is the-
very poor.
What is the pleading, my lord?
Second,
My lord,
even the mother's name is not succeeded by the name of the father.
my lord, it is the statement of the proceeding in paragraph 13 of the
Present statement.
WS that when he was aged about 2-3 years, father expired. And then mother shifted from Panduma to Bamundanga and started to reside with maternal grandparents. At page 22, Lordship may kindly have a look at the WS. Father expired, therefore mother shifted to maternal grandparents' house. And also maternal grandparents' name has been disclosed in paragraph 9.
This is again a voter list of which one? At page 50?
Is 50 is a voter list of 1997.
Where do you get the year?
My mother's name is at serial number
Where you
85.
get the year? 1997?
Yes, Lordship may kindly have a look in the down below, in the bottom. In the top, it is not mentioned, but in the down below, it is mentioned 1197.
Even 2005 is not a certified copy.
not certified.
Your name, your name appears.
2005, my name is at serial number 1176,
No, even that is not a certified copy.
no, not certified.
Your link, you have not.
Mine,
procured
against my name, there is D mark. When any D mark is put, my lord, certificate copies are normally not issued.
What is this, page 54?
Page 54, my lord, a voter list of 2015. Mother's name is at serial number 799. And petitioner's name is at serial number 801 with D mark. Here in against the mother's name, her father's name is written Usman Guni. And that is the claim of the proceeding that maternal grandfather's name is Usman Guni.
Even this is not a certified copy.
Not certificate.
Mother is aged,
Mother.
Barack
Mother,
51.
yes. 51.
Yes.
My lord, evidence in SIP was enclosed in the writ petition, but
Yes.
we cannot enclose the cross of the evidence. The certificate copy we applied for, but not furnished to us. But in record, uh, we have seen and we have taken note of the cross-examination part. Cross-examination part, may I read? my lord?
First, where is your chief in the writ petition?
SIP, yes,
Page?
page 31. It's type copy, photocopy of the
Yes, and
Original is there.
DW one. DW one.
DW1. I, Hussein Ali, son of Asadullah, alias Asadullah, aged about 37 years, by religion Islam, by profession cultivator, resident of so-and-so, do hereby solemnly affirm and declare as follows, that I am the Indian citizen by birth and my grandparents' parents are also citizen of India by birth. The name of my grandparents are late Kamal Ali Sheikh, alias Kamal Uddin, alias Kamal Devani, and late Aisha Nessa Aisha Khatun, who as citizen of India had been living at Bamundanga Part 2, Lokhipur, Goalpar, Assam. That the name of my grandparents had been entered in the electoral roll of 1966 by serial number 176, 177, house number 6, state of village Bamundanga Part 2, PS Lokhipur under 45 number East Goalpara LSC. Exhibit A. 1970 brutalist, 1970 Bhat serial number 459460 respectively at house number 139 of village 323 number Pandova, PS Lokhipur, district Goalpara, Assam under 45 number East Goalpara LSC. Exhibit B, brutalist of 1970. In 1979, Bhat serial number 54546 respectively house number so-and-so of village Pandava under 38 number West Goalpara LSC. It was extract copy of electoral roll of 1979. That my parents are late Asadullah alias Asadullah Sheikh and Asadullah, who was a citizen of India, had been living at village Bamundanga Part 2, PS Lokhipur, Goalpara, Assam, and Rohimun Nessa, Rohimun Beba, who as citizen of India had been living at village Bamundanga Part 2, Lokhipur, present PS Bogwan, Goalpara, Assam. My stepmother name was late Tuhura Khatun. My father's name had been entered in electoral of 1979 but serial number so-and-so of village so-and-so, Goalpara, Assam under 38 number West Goalpara LSC. My stepmother's name also appeared in the electoral of 1979 by serial number so-and-so, Pandava village, copy of extract 1979. That my parents' name have been entered in the electoral roll of 1985 by serial number so-and-so, respectively, village Pandova, extract C. That my mother's name has been appeared in electoral roll of 1993 by serial number 383, house number 51 of Bamundanga Part 2 under 38 number West Goalpara C, LSC against the name of my maternal grandfather, namely Usman Guni. That my mother's name have been appeared in the electoral roll of 1997 by serial number so-and-so of village Bamundanga, and against the name of my maternal grandfather Usman Ali regularly. Then para 9, that I was born at village Pandava, PS Lokhipur, district Goalpara, Assam, and brought up at village Bamundanga Part 2 under same PS and same district. Para 10, that my name have been entered in the electoral roll of 2005 by serial number so-and-so, as house number so-and-so, village so-and-so, extract of 2005. That my grandparents along with my father were shifted from Bamundanga to village Pandava under same PS, under same district due to livelihood. That when I was 2-3 years old at that time his father died Thereafter, my mother along with other family members shifted from Pandava to Pamundanga Part 2 village under same PS and under same district at the house of my maternal grandparents due to livelihood. That the name of my grandfather had been erroneously recorded in the electoral roll of 1979 as Kamaluddin and Kamal against my grandmother's name instead of Kamal Ali Sheikh. 1985 as Kamal Devani against my father's name instead of Kamal Ali Sheikh. That my grandmother's name was wrongly appeared in the electoral roll of 1979 as Aisha Khatun instead of Aisha Nessa. That my father's name had been wrongly appeared in the electoral roll of 1979 as Asatullah instead of Asatullah Sheikh, and my father's name also wrongly appeared in the electoral roll of 2005 as Asadullah Sheikh instead of Asatullah Sheikh against my name. That I am the genuine and bona fide citizen of India by birth and not a foreigner or illegal migrant as alleged in the notice. Then, my lord, my cross-examination part, I have not annexed, but I have noted down from the record. May I read, my lord?
Yeah, we will just check the records.
Yes, ma'am.
Which record?
Record.
This is with this company.
Huh?
This is different record about.
বলো একটু।
It কোন তো হলো? 3865. It will 3865.
Taking the opposite, in the opposite page of sheep.
This is the external record.
Why two records?
My lord, there was another Hussein Ali, he was declared foreigner,
By which tribunal? Same tribunal.
same tribunal. And therefore, my lord, there was some mismatching of the records, therefore that was also called for.
This is another Hussein Ali.
And
perhaps.
another Hussein Ali, father's name is different, village is also different. In page 29, the cross part, I think, and the opposite of the evidence.
Yes,
is-
you are correct. You are correct.
Yes, my lord. May I read, my lord? On oath. My grandfather's name is Kamaluddin Sheikh and grandmother's name is Aisha Khatun of village Bamundanga Part 2, PS Lokhipur. Then, now Bhagwan. My father's name is Asatullah Sheikh, son of Kamaluddin Sheikh, and my mother's name is Rohimun Bewa, within bracket Nessa, of village Bamundanga, PS now Bhagwan. My father shifted from the village Bamundanga to village Pandoma on or before the year 1979, and myself born at village Pandava but brought up at Pamundanga. My father had one brother, namely Harun, late Harun Sheikh, and his name was enrolled in the voter list of 1966-70 along with other members of family. My father's name was enrolled in the voter list of 1979-85. I do not furnish any other documents to show my relationship of my and permanent residence of my father, except the link certificate and the voter list of my father and grandfather. I also do not furnish any other documents to prove my date of birth and place of birth. Then, my lord, exhibit A is the voter list of 1966, B is 70, C is 85, D is the cow sponsor certificate. Then the extracts are there. This much evidence, my lord. So, as per
I
this,
do not furnish any other documents to show my relationship and permanent residence of any of my father except the link certificate.
it's a and voter list of my father and
I
grandfather.
also do not furnish any other documents to prove my date of birth. Date of birth, place of birth.
Yes. But in the evidence, WSN evidence, he claimed that he was born in village Bamundanga and brought up in village. He was born in village Pandova, brought up at village Bamundanga. So, my lord, his claim is that grandparents were voters in 1970. Then father 79, 85 voter list. 85 voter list certified copy is furnished. That is exhibit C. Exhibit C is this 85 voter list. So against his father's name, grandfather's name is there. So his claim is that grandparents were voter in 1966-70. So this claim has never been demolished. No rebuttal evidence to that claim. Well, that is my point, my lord. In the light of the full bench decision, paragraph 117.3 and 117.4 and paragraph 122.1 and 122.2 of the full bench decision, there has been an observation of the full bench decision that when we claim based on voter list of parents and grandparents, there shall be rebuttal evidence. Unless rebuttal evidence and the full in the Sarvananda Sunwal case also.
What is
In
the relevant
para-
paragraph? Can you repeat kindly?
Paragraph 117.3 and
Of?
11
117.3 of which one? Muslim Mandal?
full Muslim Mandal.
Muslim one. Start
And-
from there. Okay, I'll find.
Hmm? My lord, may I read the relevant paragraph? The Muslim Mandal. 11th paragraph is 117.3. One one seven point three. May I read, my lord?
Please read slowly.
For the purpose of recording the opinion as to whether the appellant number 1 is a foreigner within the meaning of 1946 Act, the evidence of the appellant number 1 himself, witness number 3, and of his wife, namely appellant number 3, witness number 4, is relevant. The appellant in his deposition has stated on oath that in the relevant electoral roll of 1966, his father's name appeared at serial number 16 against holding number 6, part 15 of village Kumulipara under number 50 Borpata LLC. The said electoral roll has been probed and marked as Exhibit S. The appellant has also deposed that his mother's name also appeared in the said electoral roll Exhibit S. That effort, the appellant number 1 has also proved the copy of National Registration Certificate NRC 1951 as Exhibit E, containing the name of his father Shukur Mahmud, whose name appeared in Exhibit F electoral roll of 1966 and Exhibit G electoral roll of 1970. The NRC of 1951 reflects the name of the appellant number 2's father Abdul Ghafoor, issued by the competent authority and marked as Exhibit N. The relevant electoral rolls of 1970 containing the name of...
Can you read the principles laid down? These are all facts.
Yes, my lord, I'm coming,
Come to
just
the principle.
now I'm coming. The principal line. The relevant electoral rolls of 1970 containing the name of Abdul Ghafoor, who according to the appellant is the father of the appellant number 2, has also been proved and marked as Exhibit O. The state did not challenge the aforesaid version of the appellant number 1 and 2 during their cross-examination. The said version of appellant therefore remains unrebutted. So this last 2-3 lines is relevant in our case also. We claim, we proceeded claim that grandparents is voter in 1966, 70, father is voter 79 and 85. That has not been challenged by the state. There is no rebuttal evidence. There is no cross-examination on this point also, as per the deposition recorded before the tribunal. So in that light of that principle, the tribunal this way cannot declare him as a foreigner.
No, what is the importance of a rebuttal evidence in the context of the observation in this full bench vis-a-vis the observation of the Honorable Supreme Court in the Constitution bench? What is Section 9,
My lord.
notwithstanding anything in the Indian Evidence Act?
My lord, rebuttal means what is claim as made by the proceeding exhibiting the voter list, that should be rebutted, denying that this is not the voter list, this is your voter
No,
list. or
see,
this is
there are two aspects. One is the rebuttal evidence.
My lord.
One is a cross-examination.
Yes,
See, unlike a civil proceeding, even if you do not cross-examine, that will be open for a consideration. That will not become automatically acceptable. Under the scheme of this present act, unlike a civil court, suppose you give evidence in chief, there is no cross. In a civil proceeding, you can say that yes, my evidence in chief has gone and there is no cross even. You have to accept it. But here, it will be open for a consideration. Accepting and consideration
My
is
lord.
different.
full bench, what the full bench said, that may be, my lord,
Appreciation.
taken note. The state did not challenge the aforesaid version of the appellant number 1 and 2 during their cross-examination.
Yes.
During cross-examination, they had to challenge, that has not
Now,
been.
if it is not challenged, then what will be the course?
Then they remains unrebutted, that
Then what
my
will be the
version is
course?
unrebutted.
Unrebutted does it mean that it has to be taken?
Yes, my plea has to be accepted,
That is not the law.
my lord. My lord,
That is not the law.
my lord. Then, my lord, similar in paragraph 117.4,
That will be subject to.
same
That is subject to
similar.
review.
My lord, knowing everything, this full bench has observed.
No, you have not, you have stopped there. It doesn't mean, it will be subject to appreciation by the tribunal. Your evidence will definitely stand will be on a higher footing, unrebutted evidence. It doesn't mean that it will have to be taken in toto by everything, by the tribunal. Tribunal will apply its mind, appreciate the evidence. Whether you have discharged the burden, ultimately you have to discharge your burden under Section 9. Whether it's cross-examination is there, rebuttal evidence are there, you have to
My lord,
discharge your burden in
My
an
lord,
independent manner.
here, my lord, in our court, my lord, in our High Court division bench, there is another decision.
Yes, please let us know.
That Idris Ali versus Union of India. In
Please.
that case, this honorable court has held that the strict role of evidence is not applicable in this
Exactly.
category case.
That is what we are trying to
Then
put to you.
if strict role is not applied, then my whatever evidence I have applied, that should be looked to, that should be considered. That is my point, my lord.
That will go against your strict rule of evidence. If there is no rebuttal,
My lord,
that is accepted. That is strict rule of evidence.
strict role evidence means no burden is not discharged or directly connected evidence, documentary evidence is produced. So therefore not accepted. This type of strict view should not be taken, my lord, according to my understanding, my lord. May I read
Let us see what is Section 9 again. Please read.
Section 9, हम तो अलग कौन से निकली evidence act section 9 corner sec
It starts with a non-obstante clause, notwithstanding anything in the Indian Evidence Act.
Lordship is asking
Section
for
9.
section 9 of the Foreigners Act.
Yes. The burden of proof.
Burden of proof. If any case not falling under section 8, any question arises with reference to this act or any other made or direction given thereunder, whether any person is or is not a foreigner or is not a foreigner of a particular class or description, the onus of proving that such person is not a foreigner or is not a foreigner of such particular class or description, as the case may be, shall, notwithstanding
Yes.
anything contained in the Evidence Act, lie upon such person.
Notwithstanding, it's a non-obstante clause. Strict rules of evidence are not there. Entire burden is upon the proceeding.
My lord. My lord, this section has been, what Supreme Court has observed in about this section 9, my lord.
Hmm.
My lord, I want to read, my lord, that observation in the case of Rohim Ali case.
No, you read the constitution bans. Sarvana Sonal has clarified everything.
My lord, Sarvan
There are-
Sonal is also in our favor. Judgment to
No, it's not a question of your favor or somebody else's favor. It is question of laying down the correct principles of law.
My lord, the same rebuttal evidence is required to be produced by the state that has been here also observed. May I read, my lord?
Please read.
Paragraph 26
Of
of Sarvananda Sonal 2005 5 SCC 665.
2005, 5 SCC 665.
665. Paragraph 26.
26, yes, please.
There is good and sound reason for placing the burden of proof upon the person concerned who asserts to be citizen of a particular country. In order to establish one's citizenship, normally he may require to give evidence of his date of birth, place of birth, name of his parents, their place of birth and citizenship. Sometimes the place of birth of his grandparents may also be relevant, like under section 6A(1)(d) of the Citizenship Act. All these facts and would necessarily be within the personal knowledge of the person concerned and not of the authorities of the state. After he has given evidence on these points, the state authorities can verify the facts and can then lead evidence in rebuttal if necessary.
If necessary.
So the state has not felt any necessity to rebut the evidence, whatever claim we have made.
The
And-
non-rebuttal will be one of the factors in the appreciation of that.
Yes,
inference.
madam. Yes,
That
madam.
would be one of the factors.
Yes,
Certainly,
yes.
but not automatic. As you know, not automatically that it will be taken to be proved if there is non-rebuttal evidence.
My lord,
That could be the position.
but
Your contention is
I-
that it should be automatic, right?
I have proved that my grandparents were citizen of India. My father is also voter in 79, 85. And so that evidence, whether it can be thrown away because some other materials are not produced in certified copies of say 85, 79 voter list or 93 voter list, whether that can be thrown away, my lord. And if throwing away, that will be applying the strict rule of evidence. That is the of this court's decision in Idris Ali. This court in Idris Ali case has held that strict rule of evidence should not be applied.
Please give the side.
My lord. Whereas, yes, 323. Hmm, 23. Paragraph 11,
Give the
I am
citation.
reading the 11 line only.
Give the citation, please.
Yes, it is not, it is reported.
Then give the WPC number.
No, it is also reported. no.
Reported. Please give the
Yes.
citation.
2020 0 Supreme Guwahati 192.
GLR
Supreme.
GLR to go over WPC number.
Yes, WPC number will be better. WPC number 4116 of 2019.
So Supreme to the citation is 2020 0.
2020 0 Supreme within bracket Guwahati
Yes.
GAU
Yeah,
192.
192.
Date of the,
The judgment decision was given on 27/2/2020. My lord. Referring the one Supreme Court judgment in the case of Union of India
kindly,
versus
kindly give the
R. Gandhi,
kindly give the paragraph,
relevant paragraph 11.
11, yes.
In under paragraph 11, last line, reverting to the case in hand, the strict rules of evidence are not applicable in a tribunal. Then in paragraph 12, nothing is required to be proved beyond reasonable doubt. This is very important line. We find that the observation of the tribunal pertaining to Exhibit 6 and 7 is perverse, and therefore the entire opinion of the tribunal suffers from perversity. Such an opinion must not sustain. So, strict rule of evidence is not applicable, and nothing is required to be proved beyond reasonable doubt like a criminal case. So, prima facie, I have established that my grandparents were voter, my parents were voter since 1966 onwards. So, I am not a foreigner. I should not be declared as a foreigner. 52. My lord, I want to refer the Supreme Court decision in the Rohimali case. Rohimali case is reported in our GLT as 2024 4 SC 97. Here in paragraph 34, the observation relating to section 9.
Knocking the door.
However, the question is that
We have read this hundreds of times.
does not does the section 9 of the act empower the executive to pick a person on random, knock or at his door?
Door.
They are
We have
to
read this. Number
tell
of times.
him. So, my lord, here is
But unfortunately, while this was being deliberated, the paragraphs of the full bench, the constitution bench was neither pointed out to the court nor referred. This arbitrary exercise it's not permitted in
My
law.
lord,
You cannot go to somebody's house and knock the door and tell him that you are a foreigner. That is not permitted. But that is an out of context observation, with all respect.
my lord, in my case, in the present case, is Lordship may kindly have a look at the ERO report. There is no signature.
Yeah, wait, consider.
And
Yes.
there is entire columns of the ERO report is blank. And in this connection, I want to rely on the judgment of Amina Khatun.
Okay. What is
Amina Khatun and 109.
WBC?
WBC, my lord, it is reported as
Reported.
2022 4 GLT 102.
A-
2022 4 GLT 102.
AMINA.
Amina, AMINA, Amina.
Okay. Which paragraph?
Paragraph 6, 7. Hello? 16. And also 16 also.
16, okay.
In para 6, may I read, my lord? In the ERO's report, which is based on the LBO's report, some doubt has been expressed about the citizenship of the aforesaid person. However, when we see the LBO's report, we have noticed that the entire format is blank except the name mentioned as Amina Khatun, wife of Ismail. As regard the various other particulars required to be filled up, there is nothing mentioned except the word absent and on the top of the format. If the basis of doubt on the citizenship of the person is based on on LBO's report, we are of the view that since the LBO report is devoid of any particular or any finding of, or for that matter any remark or observation, the said reference cannot be said to have been made after proper application of mind. Para 7. In Muslim Mandal Supra, the full bench of this court had observed that fair investigation, fair trial is one of the basic fundamental rights of a person. And it has been also observed that though investigation need not to be detailed or an exhaustive one, keeping in view the nature of proceeding of the before the tribunal, the reference by the referral authority cannot be mechanical. The referral authority has to apply his mind on the materials collected by the investigating officer during his investigation and make the reference, or being satisfied that there are grounds for materials of such reference. A referral authority, however, need not pass any detailed order recording his satisfaction, and order agreeing with the investigation would suffice, and the referral authority, while making reference, shall produce all the matters collected during the investigation before the tribunal, as the tribunal prima facie required prima facie to satisfy itself about the existence of the main grounds before issuing the notice to the proceeding, as mentioned in para 97 and 98 of the aforesaid decision. Then, my lord, paragraph 16. Paragraph 16. We accordingly direct the tribunal, learned tribunal, before issuing notice to the proceeding, must record its satisfaction about the existence of grounds, failing which the entire proceeding may be vitiated, as happened in the present case, resulting in untold inconvenience and hardship to the person concerned, and also wastage of precious time and resource of the state. If such instances recurs, it will be colossal waste of time and resource of the state, which ought to be prevented. Here, my lord, even the ERO did not sign the reference, and enter blank. How that can be a fair investigation? That can be, this can be termed as a mechanical reference. And there was a police investigation. Police has said that yes, he is not. He is a citizen of India. So, my lord, the way of the reference has been made, the way the recognition has been made in support of my claim, whatever I have made in the evidence, should be some protection is may be given, my lord. It may be remanded for fresh investigation or fresh reference, or some protection, my lord. Kuntu. What it is possible. Governmental second time this governmental no, why could they work?
If not too much signature is on the format for making reference, okay? Then you can say lecture without, even format for verification officers report, you can also say. This is not an interesting. Reference themselves. You don't see people. Yeah, don't see. Yes, Mr. Sharma?
Yes, Lordship. Lordship. As first I am saying regarding enquiry part, Lordship. Enquiry part, Lordship, I think there is nothing regarding enquiry part. This enquiry is made by the ERO, Lordship. And I think, Lordship, police enquiry is not done in this case. Although police has submitted a report, Lordship, but on what basis he submitted that report, Lordship, that was not mentioned in the report, Lordship. And apart from that, Lordship, basis of reference is only ERO's enquiry, Lordship, not this SI report, Lordship. What SI has made, Lordship. And their basis of enquiry is only ERO's report. And Lordship, regarding that, Lordship, I have on earlier occasion also, I have submitted one judgment of dishonorable court, Lordship, WBC 245 of 2019.
Name?
Name SHUKURJAN, Sukurjan Mesa.
SHUKURJA.
NESSA, alias SUKURJAN.
Report, not report.
I think, Lordship, I
Anyway,
don't know it is reported or not.
Can
Lordship,
cross-check.
But it should be reported, Lordship. Very elaborate judgment has been passed, Lordship.
WPC,
And Lordship.
245.
eh,
19.
whole judgment is important, Lordship. Everything has been discussed in this
I see.
judgment. Apart from that, Lordship, I am only at present for
Date of the judgment?
date of judgment, Lordship. 28 to 2025. Para 20, Lordship, I am just reading, Lordship, what it is said, Lordship. However, in the case of Amina Khatun was relied by my senior colleague, Lordship. However, in the case of Amina Khatun Supra, which was decided on 28/4/2022, the reference was made by the Superintendent of Police Border based on LVO by the ERO. But when the said jurisdiction was being heard and decided by coordinate bench, it appears that previous decision of the learned single judge of this court in the case of Sayamuddin versus the Union of India and others 2019 4 CLD 456 as affirmed by the division bench of this court in the case of Sayamuddin versus Union of India and others, read appeal number 170 of 2019 decided on 29/7/2019 were not brought to the notice of this court. Therefore, under such circumstances, the court is of the considered opinion that under the well-settled principle of stare decisis, the decision in the case of Amina Khatun Supra would be per inquiry. Accordingly, the decision rendered in the case of Amina Khatun Supra will also not be of any help to the petitioner. And Lordship, on earlier point how ERO report has come in Sayamuddin's case, Lordship, that part also discussed, Lordship, in this judgment, Lordship. I have only one question, Lordship.
Okay, we'll make a copy. You verify whether it's reported. It's a copy.
Yes. And second thing, Lordship.
But since we are on this issue, on this fact, there are, see, what Mr. Sigdar is harping upon, there is a communication by the who is SI.
Yes, Lord.
SI, he says, we are reading it, I have the honor to submit that the report of above the voter nationality is that the voter's grandfather's name is so-and-so, and though his father's name is not appeared in 1966 electoral rolls, his grandfather name Kalemuddin is appeared in 1966 at serial number so-and-so. Hence, the voter Hussain Ali, being Kalemuddin's grandson, is a citizen of India.
Yes, Lord.
That is the finding given. Father's name was not found, grandfather's name was found, and he comes to the conclusion he is a citizen of India. He gives this report. Now, this is one part. The second part, what Mr. Sigdar is pressing, is that there are two annexures, Annexure A and Annexure B, to make a reference. Now, the Annexure B, which is on the first page, he is correct in contending there is no date.
Lord.
No date of the ERO. He has given Hussain Ali of so-and-so reports of the LV, etc. And in Annexure A, which is the format,
My lord, in Annexure B, there is no signature of ERO also.
that is what we have said. ERO, there is no signature of anyone. There is no signature of the ERO. It is blank. Then in Annexure A, while this matter was being referred, the ERO has put his signature.
Yeah.
And accordingly, on 21/11/15, the notice was issued by the Learned Tribunal.
But Lordship, the basis of reference is the ERO's report, Lordship. ERO's report. So as we has referred the matter to the concerned foreigners tribunal for opinion only on the basis of ERO's report, Lordship. That SI has submitted a report that is not conclusive, Lordship.
Now there are, see, Annexure A, Annexure B. Annexure B has been given first, which ERO doesn't bear a signature. Annexure A, which is put here, is the LVO report. It has a signature.
Lord.
You have a look. There should not be any dispute with the factual aspects of the record. Mr. Sigdar,
My lord, my lord.
have a joint inspection.
Yes, Lordship, there is no signature, Lordship, but
That is Annexure B, which has come first of the ERO. Now turn over the page. Turn over the, then the LVO.
yes, Lordship.
LVO, then turn over the page under the reverse side. Reverse side, yes, please turn over. There is the signature.
But person is different.
Different.
Prosody is different.
LVO is different.
Prosody is son of Khalil Sheikh in that case, in the Annexure B, my lord. Annexure A. LBR. My lord, it is person is Hussain Ali of Lempara, son of Khalil Sheikh. I am not that person, my lord. That is the second case, there is another record. This is part of that record, I think.
Let us see the notice thereafter. Notice has proceeded what?
Yes, Lordship. Thereafter,
Notice to whom?
Notice that is against.
generally same person.
No, son of?
Son of Asadullah, Lordship, same as ERO's report, Lordship. And Lordship, Otherwise, Lordship, I think, those Lordship, I think Lordship, my humble submission is that Lordship, there is, petitioner is no way prejudiced regarding that on the basis, because Lordship, petitioner has approached the tribunal, contested the case, if evidence, after that tribunal come to a conclusion that the person concerned, after appreciating the evidence and on the basis of materials available on records, Lordship, tribunal come to the conclusion that the person concerned is a foreigner who comes after 1971, Lordship. Yes. So,
Humble and jumble.
Lordship, for the time being, I want to see that. Yes, yes. Lordship.
Yes.
Sorry, Lordship.
Yes.
Lordship, these two Hussain Ali Lordship, this LBO's report has been intersense in these two reports, Lordship. That is why, Lordship, these two record has come, Lordship.
Same tribunal.
Same tribunal, Lordship, this page was intersensed in both the cases.
Name is same,
Name is same. Here, LBO report.
but father's name is different.
Yes, that I have submitted initially.
Yes,
Father's name
Lordship,
and village is different.
মানে very humble and jumble manner ki
And Lordship,
documents are
what in this
clubbed together.
What in this case, Lordship, in LBO report says that Lordship, during inquiry, proceed unable to produce documents, Lordship, that much only. That is why all columns are blank, Lordship. In this.
Let us see the second record.
This is the LBO report of this first report. And
Oh. Yes, unable to produce. I don't think.
পুলিশে এইটো হুছেইন আলীটো ঢুকাইছে
এখন খালি ললি উঠতে কথা আছে খালি ললি এখন বলি সেইটো দুটার নাম একই কারণে
আমি দুটারে লেখা রয়েছে
But this is not regarding to this current writ petition 3865, isn't it?
on the LBO report.
Only the end report.
LBO report.
If this the other reference is answered and it is put to challenge, it cannot be the records of this writ petition.
Yes. It is not the record.
What has happened in this case? Was there an opinion given? No.
This is Lordship, I think Lordship, this is an party opinion. Most probably.
he submitted evidence, written evidence, subsequently died. That is the statement, my lord. In our writ petition, there is some report. Wife of that Hussain Ali, son of Khalil Sheikh, was examined, and she stated before the CDPO that her husband has expired. After written evidence, husband expired. Therefore, there was no cross-examination. For want of cross-examination, he was declared foreigner.
But that is not the discussion in the
Yes,
in the opinion. Though that opinion is not before us,
Yes,
No, we are not
Just
concerned.
have had a look. Those
only,
are,
only LGO report is gone.
Lordship, the earlier, our court has called for that record because there was some
mixing up,
my lord, mixing of the records.
Yes.
because the names being the same.
Yes, my lord.
After
Okay.
perusing both the records, it could be sorted out subsequently.
Mm.
My lord, the tribunal has not fairly acted, has not looked into records. So, yes, the tribunal is to look which documents is related to which proceedings.
Certainly.
That has been wrongly clapped, interchanged and proceeded. That means he has not acted, he acted in a illegal manner. Cognizance is mechanical. Reference, not only reference, but cognizance is also mechanical, not fair.
Yes, yes. What else, Mr. Sharma?
Lordship, I have only submitted regarding Yaro's report. Although signature is not there, Lordship, I think Lordship petitioner is no way prejudiced due to not putting the signature in the Yaro's report. And basis of reference is that Yaro's report only. Lordship.
Without signature, how it can be reference?
Lordship, regarding notice, Lordship. Lordship, this is a reported case, but I have the reported direction, Lordship. In
What is the
WBCT,
principle? Which principle?
on the basis of the notice, grounds mentioned in the notice need not be elaborate. And all very elaborate judgment Lordship is Dukhi Ali. This is reported judgment. WBC 3805 of 2016.
38
05 of 2016.
name?
Dukhi Ali.
Dukhi.
Dukhu Miad. DUKQMIAH versus Union of India. And two petitions are there. WBC 4108 of 2016.
Decision date.
And decision date 8/3/2018.
8-3.
Yes, sir.
8/3/2000.
2018. Lordship, para 20, I am reading first, Lordship. In the state of Assam versus Muslim Mandal reported in 2013, 1 809, a full bench of this court has held that a proceedee is entitled to a copy of main grounds on which he or she is alleged to be a foreigner. The issue raised by the petitioner was also raised in WBC number 2613 of 2016. Aisha Khatun versus Union of India decided on 3/10/2016. This court held as follows. Firstly, a notice is given to the noticee to make her aware of the proceeding registered against her in the case. A proceeding under the Foreigners Act 1946. Firstly, a notice is given to the noticee to make her aware of the proceeding registered against her in this case, a proceeding under the Foreigners Act 1946. Though under clause 3(1) of the Foreigners Tribunal Order 1964, it is mentioned that this so-called notice should be accompanied by a copy of main grounds on which the allegation had been made. It is open to the Foreigners Tribunal to endorse a remark or to mention in the so-called notice itself the reason for issuing the so-called notice. In the use of expression in copy of main grounds as appearing in clause 3(1) should be understood to mean the disclosure of the grounds in the so-called notice. As pointed out above, these grounds can be incorporated in the so-called notice itself, as those need not be elaborate. After all, the objective of issuing notice is to inform the noticee beforehand about the registration of the proceeding. Reverting to the fact of the present case, it has already been noticed that in the so-called notice, it was mentioned that as per reference of the Superintendent of Police, Bongaigaon petitioner was suspected to be a foreigner having illegally entered into India oblique Assam from East Pakistan oblique Bangladesh, whereafter the reference was registered. This itself is the ground for issuance of the so-called notice. Secondly, it is evident that no prejudice has been caused to the petitioner by alleged non-furnishing of a copy of the main grounds. Petitioners had filed the written statement along with documents way back on 19/10/2013, taking the stamp as indicated above. Almost 3 years thereafter, the related petition was filed by the petitioner alleging non-furnishing of copy of main grounds and seeking a copy of the same, which was rejected by the tribunal. From the above, it is more than evident that the petitioner was in no way prejudiced by non-furnishing of a separate copy of the grounds. If the petitioner is not prejudiced, which is to be demonstrated by way of pleading, which is absent in the present case, the court would not intervene in a pending proceeding before the tribunal in exercise of its writ jurisdiction under Article 226 of the Constitution of India. A mere procedural lapse would not give rise to any cause of action to a proceeding facing a proceeding before the Foreigners Tribunal under the Foreigners Act 1946 to move the writ court at an interlocutory stage. The writ court would so Lordship here. So Lordship, here sum and substance of this judgment is that notice need not be elaborate and grounds should not be furnished separately, Lordship. And Lordship, after discussing all things, Lordship, all the established principle of law, Lordship, goes come to a conclusion that dear para 29, therefore, on the thorough consideration of the matter, we have no hesitation in our mind to hold the petitioners in both the cases had due notice of the nature of the proceeding registered against them before the tribunal and what were the main grounds on which the allegation was made, because those were mentioned in the notice itself. Moreover, we also feel that both the yes, trying to delay the proceedings, etc., etc. So, Lordship, then Lordship, another important aspect of the regarding rebuttal evidence, Lordship. Rebuttal evidence.
So grounds need not be mentioned in the
Yes.
notice.
This is elaborate. Whole judgment, I am not taking Lordship, but whole judgment is detailed elaboration of
That respect.
that aspect also. And Lordship, regarding Lordship rebuttal evidence. WBC 2641 of 2016, Lordship, it is the reported case, Lordship.
Still, it helps. There can be different grounds of suspicion. It's not.
Here from the other aspect, rebuttal evidence.
Lordship, I am just relying the reported judgment, Lordship, of this honorable court. State of Assam versus Mohabali.
evidence.
It is reported in 2018 4 GLT 360.
3 GLT.
4 GLT.
Sorry.
2018 4 GLT 360 and 2018 5 DLR 421.
Same.
Same.
What is the name?
State of Assam versus Ohabali, OHAV, Ohabali. Para 16 Lordship I am relying.
So tight.
On the other hand, from the impugn order, we find that after narrating the case, as projected by the respondent, tribunal observed that state did not examine any witness and failed to adduce any rebuttal evidence. Therefore, tribunal answered the reference against the state. We are afraid the approach taken by the tribunal is contrary to the law stated by the full bench of the court in state of Assam versus Muslim Mandal reported in 2013 1-809. Under section 9 of the Foreigners Act 1946, burden is on the proceeding to prove that he is not a foreigner but a citizen of India, and this burden never shifts. This burden has to be discharged by the proceeding by reducing evidence which are admissible, which must be proved and which must have relevance to the facting issue. By mere filing of documents without examining admissibility and without the documents being proved or without examining its relevancy, it cannot be said that the proceeding has discharged its burden. Question of rebuttal evidence by the state will arise only if the proceeding adduces evidence which are admissible, proved, and which have relevancy. So, Lordship, here in this case, Lordship, proceeding has relied on the voter list of 1966, Lordship.
Nineteen 66 grandfather,
Grandfather,
Kamal Ali Sheikh and Aisha Nisa.
yes, Lordship. Then Lordship, Exhibit P is 1970 voter list. And after that, although some voter list has been placed, Lordship, there are Xerox copies of voter list, Lordship, which are not admissible in evidence, Lordship, as per Burhan Ali's case, Lordship. And then, Lordship, suddenly, in the year of 1985, they placed one voter list, Lordship, as Exhibit small a, Lordship, where projected fathers of the proceeding is 63 years and her mother's name first time reflected as Rohimon Nessa at the age of 22 years. And difference between husband and wife is more than 40 years, Lordship. I have nothing to say regarding that, Lordship, but one important aspect is
Not
that
very usual, slightly unusual.
yes,
That's
yes,
what I'm trying to say.
yes, Lordship. And one important aspect is that, Lordship, during filing of this writ petition, Lordship, proceeding is aged about 39 years. Then he sometimes born in the year of 1978. And in the voter list of 1985, his mother's was about 22 years. So, Lordship, proceeding was born when his mother was about 15 years old. And prior to 1985, Lordship, there is not a single document of his projected father, Lordship, although he was 63 years old in the year of 1985, Lordship. So, again, and Lordship, Lordship, proceeding 1966 voter list, Lordship, then 1970 and 1979 is not exhibited, Lordship. It is Xerox copy of the voter list. And 1985 was exhibited as exhibit small a. And then 1993, Lordship, it is not exhibited, Lordship. Burhan Ali's case, Lordship, after thorough discussion, WPC 7669 of 2016. It is reported case, Lordship, but I cannot recollect, Lordship.
Please give the number.
7669 of 2016.
7669
Yes, sir.
of
2016. Decided
name
Burhan Ali,
BOR,
BORHANALI.
date of disposal
Date of disposal 8/6/2015.
15, cannot be
18, Lord.
18.
8/6/2018. So, Lordship, what para 21.7, Lordship. After discussion, Lordship, it was stated as, therefore, if a procedure relies on a voter list, only a certified copy of such voter list or extract thereof would be admissible in evidence. Filing of an unsigned or unauthenticated or uncertified copy of the voter list sought to be relied upon as a proof of citizenship would not be admissible in evidence. Therefore, we would respectfully disagree with the second by Chencho. Somewhere, Lordship, I could not find, Lordship. Petitioner stated that Lordship, as fathers of the petitioner is mentally disturbed, Lordship, that is why, Lordship, his name is not appearing in the voter list prior to 1985. But there is no proof, only statement is there, Lordship, that he is mentally disturbed. And from when he is mentally disturbed, because, Lordship, Prosody was born in the year of 1978, as per his affidavit. He was 39 years in the year of 70. So that part is not there. So, Lordship, I think there is no infirmity in the opinion passed by the learned tribunal, Lordship, and Prosody is getting enough scope before the tribunal to prove his case, Lordship, and but he could not able to discharge his burden that he is a citizen of India, Lordship. So there is no infirmity in the opinion passed by the learned tribunal, so the opinion may not be disturbed, Lordship.
My lord, I have stated something like a mental disturbance, but that is, I am sorry for that statement, my lord. That is beyond record. Record goes to show that her husband, the father was expired. Therefore, father was not enlisted in the voter list. What I have stated regarding his mental disturbance, that is beyond record. I have wrongly said, my lord. I may be excused for that.
Then Lordship till 1985 father is
Yes.
alive, Lord.
Yes,
Lordship.
that is there. So,
But prior to 1985, there is no father is Lordship.
but my last submission is that there cannot be, as per submission of my friend,
Your father is Asadullah. Who is your father?
my father is Asadullah.
Asadullah.
My submission is that there was no
What
reference at
what
all.
is your present age, Mr. Sikdar?
My lord,
at the
as
time
per
of-
FIR,
At the time of
sorry, as
filing?
per the affidavit and declaration, my lord,
39 years.
39 years,
When? 2000?
2017.
As on
Yes.
today? Last
That
8
it will
years.
be
Last 8
8
years.
years,
Date of birth will be
8 years.
Around
It will be about
45 years.
47,
47.
like that.
47. 47.
My last submission is that as per submission of my friends, there was no reference at all because the ERO reference is the reference and there is no signature of ERO. Without signature, how it can be valid documents of reference? My lord?
What is the distinction between the report of the LVO and the report of the ERO?
My lord, reference, ERO is the reference. ERO, whatever submitted report, that is the reference. And LVO is the report, materials collection, local verification. That is the difference. My lord. LVO is the report and ERO is the referral authority.
No,
Yes,
FP is the referral authority. Lord.
but here you are saying that it is a ERO reference.
No,
It is your submission.
ERO
The referral authority is the SP border or
Yes.
DCP border.
Yes,
These
but
are materials which are taken into consideration by the SP referral authority. So we are asking you, what is the difference between an ERO and an LVO so far as the value of the report is concerned?
yes, the reference, the report of the LBO is the material collection. And based on that materials, ERO made report to the SPO. But sometimes directly to the tribunal also. There are so many cases, ERO made reference directly to the tribunal. But
Okay, we'll consider. We'll
Mile.
consider. Okay, Ali Khan, A.R. Sikdar, G. Hazarika, G. Sharma, Hazarika for State Council, M. Islam on behalf of A.I. Ali, and anyone for CGC? R.K.D. Chaudhary.
my lord, I have another matter, my lord. I want to get
Even if you
rid
say
of
you,
that item
even if
nine.
you say you want to do, will not do your matter.
Item
My
9,
lord.
my lord.
Malad, I'm sorry, Malad, item 20.
Why are you sorry?
Item 20, when call, I am not there.
You need not be sorry now.
Now, Malad, item 20, Malad, as far as I am concerned, our name may be deleted, except P. Rahman. The P. Rahman is the conducting lawyer, my lord. The name of my name.
Here, Mr. P. Rahman, why are you worried?
No, that our name may be there is some, we are facing some difficulties because we have no file. And Quasar listed,
We'll not insist on your presence. Who is P. Rahman?
P. Rahman is not available here.
He will be there, we will not.
Our name may be deleted, my lord.
See, deletion of name requires a very technical and complicated process.
Because in fact, since long back,
We can
I-
we can observe, but
I am appearing without any file, man. I am since long back.
pro bono.
In that case. Also, I was engaged in
But
this
we have
case.
already passed the order, I think, 20 passport order passport.
For time being, it was.
Okay, 20 likha. Sri J. Ahmed Learned Counsel for the petitioner has submitted that he and his colleagues
Except
except Sri
P.
P.
Rahman,
Rahman
Atas full name.
are no longer connected with this matter as counsel, and therefore their names may not be reflected in the cause list. Para? registry may take note of the aforesaid submission and reflect the name of Sri P. Rahman as the counsel for the petition.
Hello.
List after a week. Yes, and a very small case which can be finished in 10 minutes. Where is Mr. Mohanta? We have seen Mr. Mohanta. Yes? Where is the senior?
Lordship, can it be fixed first day, Lordship, because both of the senior advocates asked me.
No, if you don't want to do, you don't need to mention. If you want to do, you make a mention.
Lordship,
Mr.
it will
Goel,
take
what is your matter?
43.
How long will it take?
10 to 15.
10 minutes only.
10
What is the
minutes.
matter?
That, my lord, foreigners matter.
Foreigners,
been declared
foreigners will
for-
not be finished in 10 minutes.
Only I have to place document, law, your lordship will take care of it.
10 minutes is not going
My
to be
lord,
over.
that is another date.
Any matter where 10 minutes it can be completed. Mr. Dubey,
Permit, you can take a chance on that.
foreigners,
No, it's a review matter arising out of surfacey proceedings.
review.
Yes.
Review will be very happy to dismiss. Please do. Other side, review again review a judgment by whom?
By-
Not by us, definitely not by us. By a bench which is not available now.
Yes, yes.
What is the review? On what ground are you seeking review?
But what has happened, a surfacey proceeding was initiated, auction was made, and it was during the COVID period in 2020, and we had challenged the auction before DRT, Guwahati. That review was, DRT as appeal was dismissed. Then we carried it before the appellate tribunal in Kolkata, there also it was dismissed. Then it was challenged before your lordship in writ petition. Your lordship was pleased to dismiss the writ petition. Then-
Dismiss.
Yes. Then it was again taken before the apex court in SLP. SLP was also dismissed. We also filed a review there, and that was also dismissed. Now we have come before your lordships, lords.
Review for, on what ground?
Basically, your lordships has, while passing the impugned judgment,
Yes.
the unamended provision of the Surfacey Act has not been taken into consideration in one aspect, because
But this point you have taken up in the appeal.
but appeal before apex court, that has been dismissed in limine. I have judgment from the apex which says that it doesn't merge, and rejection of SLP is not
Then
granting
what is
leave.
the appellate court's order, writ appellate court's order, writ appellate court's order?
We have come in a writ petition before division bench, and then we file a SLP. So my contention for your lordship's consideration is, since leave was
Oh,
not,
it was initially before a DB.
yes, because the writ proceedings
Okay,
are
division, okay, oh,
Well,
surfacey, okay.
surfacey. So, the law is
Doctrine of merger will not apply.
not applying.
What is the language? What is the language employed in the SLP?
SLP, leave has not been granted.
No, what is the, how has it been dismissed?
Yes, Millard. Upon hearing the counsel, the court made the following. In the facts of the present case, we find no reason to deviate from the view taken by the High Court, inasmuch as the petitioner had failed to
This is
exercise.
not a limine order.
No, Millard.
All orders are not necessary to be
Millard,
Supreme Court's order.
Millard, I am relying upon apex court judgment, Millard, which says, Millard, even if there are reasons, Millard, reasons has not been given. Millard, if leave has not been granted, I'll just straight away I'll show you the judgment before your lordship, Millard, because I have to cross that hurdle, Millard, before I get into the merit of this case.
Difficult. You have got double hurdles.
Millard, I'll try to pursue
And
your
which
lordship.
hurdle is more tough, we do not know.
Millard,
Which hurdle is the tougher, we do not know. Each one appears to be the tougher than the other.
no, Millard, in my restful submission, Millard, none of them is tougher, Millard. I can say through.
Second one is the toughest. First one, even if you cross over, Second one, you'll not be able to cross.
My lord,
through it.
your lordship has interpreted the law in correct way, my lord, but while applying, my lord, my factual aspect has not been taken into consideration,
Today, we will not,
My
we'll have it to some other day.
my lord.
We'll try this on Thursday.
Thursday, my lord.
Lordship, this is, I am for the exponent number one, purchase,
Hmm.
option purchase.
Hmm.
I have been dragged on since I purchased from the.
Is there any interim order?
There is no interim order
Then-
as of such. I am the option purchaser, exponent number one.
Hmm.
So I've been dragged on all the from the DRD to the Supreme Court and.
Yes,
and
yes.
from here.
Okay.
And my limited uses, there has been the, only the petitions which they, only the point, which they have asked for is that the 15 days or the 30 days notice, which was to be given, was not given, and the DRT, the High Court, the DRAT, and the Supreme Court says no. Every formalities was done. So from right again from the Supreme Court, then again it comes to this honorable court.
So what is your difficulty, except for standing here? Is your client suffering any prejudice?
Actually, this should not be, this should not brought in this notices that.
Can you
after-
prevent somebody from filing a review? We can, if he doesn't make out a case, we'll dismiss it. You can ask for imposition of cost, we'll consider.
Yes. Well, though bank has been served, my lord, they are not appearing. your
Who's the
lordship.
bank?
This is, the bank is. the
Which
of
bank?
India,
Huh? Bank of
Bank
India.
of India.
Is it still there?
It is there.
Not amalgamated?
From the day one, they have not came here.
Served?
Sub, that has been recorded.
In fact, we have also asked them to come down.
But they have got money from both sides from us.
No, you can pay for cost.
Yes, yes, I am ready if I cannot convince your lordship, my lord.
But cost he'll not get. Cost will go to the bar,
Anyway, some-
bar association.
Okay,
You-
but I think we should ask for cost right now.
My
As
friend
of
got-
today, he'll treat you with some coffee. That is the cost. Okay, great. It's okay. Okay, rest will give dates.
My lord.
Good.
क्या बोलते हो?
Hold on.
Good.